2015 arrangement of sections Part 1 Preliminary 1. Interpretation. 2. Application. 3. More favorable terms and conditions not precluded. Part 2 Administration. 4. Establishment of Labor Department. 5. Duties and responsibilities of Commissioner. 6. Institution of Proceedings. 7. Commissioner to have powers of Inspector. 8. Designation of Labor Inspectors. 9. Duties and responsibilities of Inspectors. 10. Powers of Inspectors. 11. Of premises where domestic servants are employed. 12. Notification of presence. 13. Limitations and restrictions on Inspectors. 14. Records and returns. 15. Obligations of employers. 16. Annual Report. 17. Obstruction to Commissioner and Inspectors. 18. Liability of agent, etc. 19. Limitation of liability. 20. Victimization. Part 3 Settlement of Disputes. 1. 21. Procedure for the settlement of disputes. 22. Action by Minister. 23. Limitation on industrial action. 24. Establishment of arbitration tribunal. 25. Findings of tribunal binding. 26. Powers of tribunal to summon witnesses and administer oaths. 27. Summons of tribunal to be obeyed. 28. Failure to obey summons of tribunal. 29. Tribunal to regulate own proceedings. 30. Arbitration ordinance not to apply. Part 4 Advisory Committees. 31. Tripartite consultation. 32. Advisory Committees. 33. Reports of Committee. Part 5 Fundamental Principles and Policies. 34. Promotion of core labor standards. 35. Policies underlying the Code. Part 6 Basic Conditions of Employment. 36. Particulars of Employment Contracts. 37. Probationary Period. 38. Rest periods and standard working hours. 39. Meal intervals. 40. Overtime pay. 41. Payment where employee stopped or prevented from working full day or shift. 42. Pay for period of standby or being on call. 43. Payment in respect of public holidays. 44. Distribution of service charge to Part 7 Protection of wages. 45. Agreement to pay wages otherwise than in money. Illegal. 46. Agreement as to manner of spending wages. Illegal. 47. Wages to be paid entirely in money and not otherwise. 48. Wages to be paid directly to employee. 49. Wages not to be paid on certain premises. 50. Pay periods. 51. Authorized deductions. 52. Prohibited deductions. 53. Payment of wages on termination of employment. 54. Remuneration other than wages. 55. Employee right to recover. 56. Wages to be a priority. 57. Limitations on attachment or seizure of wages. 58. Employer to issue details of wage deductions. 59. Cooperative work. 60. Offenses. 61. Repayment of wages. 62. Actual offender to be prosecuted against. 63. Prosecution to be instituted in a year. Part 8 Minimum wages. 64. Fixing of minimum wages. 65. Establishment of Minimum Wages Committee. 66. Procedure. 67. Publication of recommendations. 68. Matters for consideration in proposing minimum wage. 69. Effect of minimum wage order. 70. Posting of minimum wage order. 71. Offenses. PART 93 LEAVE 72. Annual holiday terms and conditions. 73. Payment in respect of annual holiday. 74. Exclusions. 75. Paid annual holiday upon termination. 76. Sick leave. 77. Maternity leave. 78. Additional period of maternity leave. 79. Amount of maternity leave pay. 80. calculation of maternity leave pay 81. Maternity leave 82. Employee not to be given notice of dismissal while on maternity leave 83. Special leave for jury service and other purposes 84. Penalties and employees' right to recover PART 10 disciplinary action, termination of employment and continuity of employment 85. Disciplinary action by employer 86. Valid reason for disciplinary action and dismissal 87. Unfair dismissal 88. Constructive dismissal 89. Summary dismissal for serious misconduct 90. Warning and termination for misconduct 91. Unsatisfactory performance 92. Dismissal for reason of incapacity or abuse of sick leave 93. Termination during probation 94. Termination with notice 95. Time off to seek alternative employment 96. Remuneration upon dismissal 97. Burden of proof 98. Remedies for unfair dismissal 99. Recovery of wages and notice pay 100. Winding up of employer's business 101. Death of employer 4. 102. Certificate of employment 103. Continuity of employment 104. Rights of employees on change of ownership 105. Effect of sale of business 106. Termination due to RADUND and ACY 107. Criteria to be used in selection of employees for redundancy 108. Severance pay 109. Retirement benefits PARTIIQUALITY treatment in employment 110. Objectives 111. Definition of discrimination .112. Prohibition of discrimination .113. Bona fide occupational qualifications 114. Citizens preference .115. Special positive action .116. Sexual harassment 117. Equal remuneration .118. Partnerships .119. Employer and employee organizations 120. Inducement to discriminate .121. Burden of proof .122. Offenses and penalties under this part. Part 12 Protection of Children and Young Persons 123. Prohibition of employment of children .124. Liability of parent or guardian .125. Restrictions on employment of young persons .126. Registers to be kept .127. Offense 128. Inducement 129. Unpaid work 130. False representation as to age .131. Government's vacation work program for students. 5 Part 13 Forced labor 132. Interpretation .133. Prohibition of forced labor .134. Application to government Part 14 Health, Safety and Welfare 135. Interpretation .136. Duties of employers .137. Registration of workplaces .138. Risk assessment .139. Safety and health policy and emergency plan .140. Health .141. Safety .142. Welfare .143. Special protective measures .144. Protective clothing and devices .145. Hazardous materials .146. Special protection for pregnant employees .147. Employment of young persons or dangerous machines .148. Disposal of waste .149. Noise and vibration .150. Obligations of persons employed .151. Prohibition of deduction of wages .152. Safety and health representatives .153. Joint workplace safety and health committees .154. Special powers of inspector .155. Reports by employer .156. Duties of owner .157. Exemptions and extensions .158. Regulations and Orders 159. Non-exclusivity of provisions of this Part. 160. Offenses. 161. Multiple offenses. 162. Penalties for specific offenses. 163. Power of court to order cause of contravention to be 6. Remedied. 164. Penalty for person actually committing offense for which operator is liable. 165. Proceedings where inspector or operator believes the offender. 166. Records as evidence. 167. Other remedies. Part 15 work permits. 168. Interpretation. 169. Application. 170. Prohibition against employment. 171. Applications for work permit. 172. Action upon application for work permit. 173. Penalty applicable to employees or self-employed persons. 174. False statements in application, etc. 175. Fees. 176. Penalty applicable to employers. Part 16 trade unions and employers organizations. 177. Interpretation. 178. Exemption. 179. Basic employee rights. 180. Freedom of association protection for employees. 181. Protection of trade unions from employer interference. 182. No compulsion to join or not to join a trade union. 183. Membership. 184. Federation. 185. Remedies. 186. Register of Trade Unions. 187. Registration. 188. Constitution. 189. Alterations in Constitution or Name. 190. Annual returns to Registrar. 191. Legal status. 192. Amalgamation. 193. Defunct organization. 7. 194. Restraint of trade not unlawful. 195. Prohibitions of actions of tort against trade unions. 196. Conspiracy in relation to trade disputes. 197. Removal of liability for interfering with another person's business. 198. Peaceful picketing. 199. Cancellation of certification of registration. 200. Officers, accounts and audit. 200. Withholding or misapplying trade union effects. 202. Registration. 203. Registered office of union. 204. Membership of minors. 205. Improper election practices. 206. Deposit and safeguard of funds. 207. Application procedure for certification. 208. Certification particulars. 209. Appropriateness of bargaining unit. 210. Employers' recognition or notice. 211. Certification following employers' recognition. 212. Majority trade union determined by Poll 213. Employer duties and conduct of Poll 214. Restrictions in conduct of Poll 215. Employee duties and conduct of Poll 216. Granting or refusing certification. 217. Compulsory recognition and duty to negotiate in good faith. 218. Duty of fair representation. 219. Closing of undertaking. 220. Effect of certification as the registered majority union. 221. New collective agreement. 222. Revocation of exclusive bargaining rights. 223. Right of appeal. 224. Right to choose representative. 225. Access to employer's premises. 226. Collective agreements. 227. Enforceability of collective agreements. 228. Successor rights and obligations. 229. Penalties where not fixed penalty specified. PART 17. Miscellaneous. 230. Limitation upon prosecution. 8. 231. Conflict between the code and other law. 232. Penalty or no fixed penalty is specified. 233. Regulations. 234. Repeals and savings. Schedule 9 and below now. Of 2015 Part 1 Preliminary Interpretation 1. in this act, unless the context otherwise requires. Bargaining agent means a trade union that acts on behalf of employees for the purposes of collective bargaining. Bargaining unit means a group or category of employees on whose behalf collective bargaining may take place. Casual employee means an employee whose employment is irregular, of short duration and sporadic. Child means a person under the age of 16 years. Cohabitant means a person who is living or has lived with a person of the opposite sex as a husband or wife for a period not less than 2 years, although not legally married to that person. Collective agreement means any contract between one or more employers or the organization representing employers and two or more employees or the trade union representing employees concerning terms and conditions of employment or any other matter of mutual interest. Collective bargaining means negotiation between one or more trade unions and one or more employers or employers' organization for the purposes of concluding a collective agreement. Commission agent means an agent or employee who is remunerated by commission. 10. Commissioner means the person for the time being appointed to, or acting in, the post of labor commissioner. Conditions of employment refers to the elements of hire and termination of employment, the remuneration, hours, duties and the surrounding terms of employment and to all other factors directly related to the employment arrangement. Confinement means labor resulting in the birth of a living child or labor, after not less than 28 weeks of pregnancy, resulting in the birth of a child, whether alive or dead. Continuous employment means an uninterrupted period of employment with an employer, and any predecessor employer, provided that any break in employment not exceeding 6 months shall not be deemed to break continuity of employment. Constructive dismissal means termination of a contract of employment by the employee as a result of conduct by the employer such as to make it unreasonable to expect the employment relationship to continue. Dependent contractor means a person, whether or not employed under a contract of employment and regardless of the person's classification, who performs work or services for another person for compensation or reward on such terms and conditions that he is in relation to that person in a position of economic dependence on, and under an obligation to perform duties for that person, more closely resembling an employment relationship than that of an independent contractor. Dispute means any difference between one or more employers or organizations representing employers and one or more employees or the trade union representing employees relating to any matter covered by the code or any law relating to labor generally arising out of the relationship between the employer and the employee, including A. terms and conditions of employment or the physical conditions in which an employee is required to work. B. Engagement or non-engagement, or termination or suspension of employment of one or more employees. C. Allocation of work as between employees or groups of employees. Or D. Any matter affecting the privileges, rights and duties of any employer or organization representing employers or of any employer representing employees. 11. Employee means any person who works under or where a contract of employment has been terminated for any reason. A person who worked under a contract with an employer personally to perform any services or labor, whether the contract be oral or written, expressed or implied or classified as casual, part-time or temporary, and the term may include A. A person whose services or labor have been interrupted by a suspension of work during a period of leave, temporary layoff, strike or lockout. B. An apprentice whose services or labor may be designed primarily to train such apprentice. C. A commission agent. D. A dependent contractor. And E. A managerial employee who is not responsible for policy formulation or an effective control of a department or branch of the undertaking, provided that such person is in an employment relationship. Employer includes a person or entity who or which employed or employs a person under an employment contract, whether directly or through an employment agency or other third party, and includes the heirs, successors and assigns of an employer. Employment contract means any contract, whether expressed or implied and whether written or oral, under which it is agreed that one person, the employee, will perform certain services for another, the employer, in an employment relationship. Employment relationship means a relationship where one or more of the following characteristics are present. A. The work: is carried out according to the instructions and under the control of another party, involves the integration of the worker in the organization of the enterprise, is performed solely or mainly for the benefit of another person, must be carried out personally by the worker, is carried out within specific working hours or in a workplace specified or agreed by the party requesting the 12 work, is of a particular duration and has a certain continuity, requires the worker's availability, or involves the provision of tools, materials and machinery by the party requesting the work. B. Periodic payment of remuneration to the worker. The fact that such remuneration constitutes the worker's sole or principal source of income. Provision of payment in kind, such as food, lodging or transport. Recognition of entitlements such as weekly rest and annual holidays. Payment by the party requesting the work for travel undertaken by the worker in order to carry out the work, or absence of financial risk for the worker. Essential services means services whose interruption is deemed by the minister to endanger the life, personal safety or health of the whole or part of the population in Angola and is limited to air traffic, including meteorological, telecommunications, security, fire and crash services connected with airports, electricity, water, fire, medical and health, telecommunication services, police, prisons and ports. Hazardous materials means a substance or material determined to be capable of posing an unreasonable risk to health, safety or property. Inspector means any person appointed as labor inspector under the code. Lockout means A. The exclusion by an employer of any or all of his employees from any premises in which work provided by the employer has been performed. Or B. The total or partial discontinuance by the employer of his business or the provision of work, with a view to inducing his employees, or any person in the employ of any other employer or employers, to agree to, or to comply with, any demands or proposals relating to any dispute, or to abandon any demand or modification of any demand. 13. Minister means the minister responsible for labor. Night work means work performed between the hours of 10 p.m. on one day and 6 a.m. on the following day. Parent or guardian means a parent or guardian of the child or young person and includes any person who is liable for the maintenance of, who has the custody of, or who has control over, a child or young person, or who has or would have a direct benefit from the earnings of the child or young person. Part-time employment means an employment contract, or a succession of employment contracts, with the same employer or successor employer, in which an employee is required to provide his services at intervals, so that the employee is not, in any 12-month period, continuously employed by that employer, and the term includes casual employment. Predecessor employer, in relation to the employment of a person, is one who, in consequence of a change occurring in the ownership or in that part of an undertaking in which that person is involved, is no longer the employer of that person. Probationary period means the period which is required for an employer to assess the suitability and competence of a new employee for the job for which he is employed. Recognized trade union means a trade union recognized and certified as a bargaining agent for a bargaining unit. Redundancy has the meaning ascribed to in Section 106. 2. Remuneration means the wage and any additional benefits, service charge, severance pay, retirement benefits, allowance or emoluments whatsoever payable directly or indirectly, whether in cash or in kind, by the employer to the employee and arising out of the employee's employment. Serious misconduct includes fraud, dishonesty, willful damage to property, possession of illegal drugs or firearms or repeated abuse of alcohol while on duty, breach of confidentiality, willful neglect of reasonable instructions from the employer or any other act of such a nature it is unreasonable to expect the employer to continue employment of the employee during the notice period. 14. Service charge means the fee or gratuity charged by a restaurant or hotel or other service provider, based on a percentage of the basic fee, that is additional to the basic fee or charge for food, accommodation or related services. Severance pay means remuneration to which an employee whose employment is terminated on grounds of redundancy. Sexual harassment means unwanted or inappropriate conduct of a sexual nature in the workplace or in connection with the performance of work which is threatened or imposed as a condition of employment on the employee or which creates a hostile working environment for the employee. Strike means the cessation of work by a group of employees acting in concert with a view to inducing the employer to agree to demands or proposals relating to a dispute. Successor employer, in relation to the employment of a person, is one who, in consequence of a change occurring in the ownership of an undertaking or in that part of the undertaking in which the person is involved, has become the new employer of that person. Wage means all earnings payable for the work or services performed by an employee, exclusive of A. Commissions and allowances, B. The value of any accommodation, supply of electricity, water, medical attention or amenities, supplied at the sole expense of the employer, c. Any contribution paid by the employer to any pension or provident fund scheme or social security, d. Any traveling allowance or the value of any traveling concession, e. Any sum paid to an employee to defray special expenses incurred by the employee due to the nature of the employment, and e. Any tips, severance benefits or retirement benefits. Workplace means a place at which work is performed, and includes property belonging to or occupied by the government. 15. Young person means a person who has ceased to be a child and who is under the age of 18 years. Application 2. The code shall apply to all employers and employees except I. The police. 2. Those employees of the Crown whose employment is governed by general orders. 3. Persons entitled to diplomatic immunities under the Diplomatic Immunities, Representatives of Overseas Countries Act, RSACD 20. IV. The master or member of the crew of a vessel if he is paid exclusively by a share in the profits, providing however that parts 11, 12, 13, 14 and 16 shall bind all employers, including the Crown, and employees. More favorable terms and conditions not precluded. 3. 1. The provisions in the code are the minimum standards that apply to employment relationships and nothing precludes an employer from conferring upon his employees more favorable terms and conditions of employment. 2. A provision in a contract of employment or collective agreement shall be void to the extent that it purports to exclude or limit the minimum standards set out in the code. Part 2 ADMINISTRATIO and Establishment of Labor Department 4. 1. There shall be a Labor Department under the direction of the Minister. 16. 2. The Governor, acting after consultation with the Public Service Commission, shall appoint the Commissioner and such other officers and clerks of the Labor Department as from time to time may be necessary. A. Ensure the enforcement of the code and such other laws that he may be required to enforce. B. Assist through conciliation in the resolution of any question arising out of employer-employee relationships, including disputes. C. Bring to the notice of the Minister promptly any matter which in his opinion is or is likely to be prejudicial to the welfare of any class or group of employees or employers. C. Receive and process applications for work permits in accordance with established regulations, policy and procedures. D. Provide professional advice and make recommendation to the Minister on labor matters. E. Provide technical advice to employers and employees and their respective organizations at their request on matters relating to the code. F. Promote social dialogue and effective cooperation between the government, employers and employees administration of the code. H. Collect data and statistics in a format agreed by the Director of Statistics in relation to I. Applications for and the granting of work permits. 2. Complaints received and settled. Duties and responsibilities of the Commissioner. 5. The Commissioner is responsible for the day-to-day administration of the Labor Department and subject to the direction of the Minister. Shall 17. 3. Inspections completed. IV. Violations of the code. V. Accidents and injuries. VI. Occupational diseases. VA. Strikes and workdays lost due to strikes. And VI. Any other key indicators of the labor market. I. provide job registration and placement services, and promote employment opportunities for nationals of any law. J. Promote regional and international cooperation in labor matters and ensure preparation of reports on application of conventions of the International Labour Organization that are extended to Angola. K. Prepare and furnish the Minister with the annual report of the work of the Labor Department. L. Do any other thing reasonably necessary for the effective administration of the Code and the promotion of good industrial relations practices, the promotion of international labor standards and the decent work agenda of Angola. Institution of Proceeding 6. Subject to the Constitution of Angola, the Attorney General, upon information laid by the Commissioner, may commence proceedings in respect of any offense committed under the Code, and the legal representative or police officer may prosecute such proceedings on his behalf. Commissioner to have powers of Inspector 7. The Commissioner shall have the powers conferred upon an inspector. 18th Designation of Labor Inspectors 8. 1. The Governor may, by order published in the Gazette, designate a public officer as an inspector to assist the Commissioner in the execution of his duties. 2. There shall be 2 categories of inspectors. A. Inspectors to monitor and enforce provisions of the Code relating to basic terms and conditions of employment, protection of wages, minimum wage, leave and work permit. And B. Inspectors to monitor and enforce safety, health and welfare provisions of the Code. 2. An inspector shall be furnished with a certificate of appointment in the form prescribed and, when visiting any premises or questioning a person in connection with the exercise of his powers, shall produce the certificate. Duties and responsibilities of inspectors. 9. An inspector shall, under the general direction of the Commissioner, A. Ensure that the laws enforced concerning conditions of employment and the protection of employees in their occupation are applied. B. Give technical information and advice, whenever necessary, to employers and employees on the most effective means of complying with existing laws. C. Submit to the Commissioner written inspection reports, indicating difficulties or abuses not specifically covered by the Code or other existing laws. D. Keep records, compile statistical data and make returns in the course of his duties as instructed by the Commissioner. And 19. E. Assist, as required, in the resolution of disputes or complaints. Powers of Inspectors. 10. 1. An inspector shall have the power to A. Enter freely without previous notice at any hour of the day or night during the working hours of the business, any workplace liable to inspection. B. Interview alone or in the presence of witnesses, the employer or any person in the workplace on any matter concerning the application of the Code. C. Carry out or cause to be carried out any examination, test or inquiry which he may consider necessary in order to ensure compliance with the Code. E. Require the production of any books, registers or documents, required by the Code, relating to conditions of employment, and to investigate whether they comply with the Code, and copy such documents or make extracts from them. F. Enforce the posting of notices as required by the Code. G. Take or remove from any workplace for purposes of analysis, samples of materials and substances used or handled, subject to the employer or the employer's representative being notified at the time of such taking or removal of any such samples or substances. H. Require from any employer information regarding the number, wages, hours and conditions of employment of the employees, or returns of such information. And I. Secure a workplace in the event of an accident to ensure that the workplace or any part or thing therein shall be left undisturbed for so long as is 20 reasonably necessary for the purposes of any examination or investigation. 2. An inspector may be accompanied by a police officer or any other employee of the Crown who has power under any other law to inspect workplaces and to any place where the inspector has reasonable cause to apprehend serious obstruction in the execution of his duty. 3. A person aggrieved by the action of an inspector in the exercise of a power under this section may seek redress from the Commissioner. 4. Where the aggrieved person is dissatisfied with the decision of the Commissioner, he may apply to the tribunal for an appropriate remedy. Inspection of premises where domestic servants are employed. 11. Notwithstanding Section 10, 1, A and B, An inspector shall not visit or inspect any private premises where domestic servants are employed or believed to be employed except between the hours of 9 a.m. and 6 p.m. and in the presence of the employer or his representative. Notification of presence 12. An inspector shall inform the employer or his representative of his presence as soon as practicable, unless he considers that such notification may be prejudicial to the performance of his duties. Limitations and restrictions on inspectors 13. 1. An inspector shall a. not have a direct or indirect interest in any enterprise under his inspection or supervision, b. not reveal at any time manufacturing or commercial secrets which may come to his knowledge in the course of his duties, and c. treat as confidential the source of any complaint regarding the breach of the code and have no 21 obligation to inform the employer that a visit of inspection was made in consequence of a complaint. 2. A person who contravenes this section commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Records and returns 14. 1. An employer shall, at an address in Anguilla, keep in such form as the Commissioner may approve, a. an accurate record in respect of each employee showing I. the employee's name, address, occupation and hiring dates either by the employer or by a predecessor employer. 2. The immigration status of the employee and the date of expiry of the employee's work permit. 3. The number of hours worked each day in each pay period, i.e. the basic and other wages paid to the employee for each pay period, v. the leave taken by the employee by type, duration and date, vi. the personal protective equipment issued to the employee, and b. a register of all employees under the age of 18 years, and, where applicable, shall keep at that address a copy of each written statement of working conditions furnished to an employee. 2. Where an employee's services have been terminated for any reason, an employer shall preserve the employee's records and the 22 written statements referred to in subsection 1 for a period not less than 6 years after the date of termination. 3. Upon request by an employee, the employer shall make available his record for inspection and copying by such employee or his representative in the presence of the employer or his representative. 4. An employer who contravenes subsection 1, 2, or 3 commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Obligations of employers 15. An employer whose premises are being visited by an inspector shall a. permit the inspector access to the workplace, b. furnish the inspector with any information as will enable him to carry out his duties, and c. grant to the employees and their representatives every facility for communicating freely with the inspector. Annual Report 16. The Commissioner shall, on or before the 31st of March in each year, prepare and furnish the Minister with a report in such form as the Minister may approve on the operations of the Labor Department during the preceding calendar year, including a. unaudited revenue and expenditure statements, b. the number of I. jobs created and jobs lost, 2. work permits received and granted, 3. workplace accidents, i.e. workdays lost due to industrial action, v. strikes, 23. vi. inspections undertaken, va. infringements of the code, vi. complaints received from employees and employers, x. disputes settled by the Commissioner, Minister, and the Tribunal, d. a status report on occupational safety and health, and e. other information as the Minister may specify in writing. And the report shall be laid before Parliament by the Minister not later than 3 months after receiving the report. Obstruction of the Commissioner or Inspector in the exercise of their powers and duties 17. A person who without good reason a. hinders or obstructs the Commissioner or an Inspector in the exercise of the powers and duties conferred on him by the Code, b. fails or refuses to permit his employees free access to and communication with an Inspector while on a visit of inspection, c. refuses or willfully neglects to furnish the Commissioner or an Inspector any information or return or particular that may be required of the employer under the Code, or d. knowingly furnishes, or causes, or allows to be furnished to the Commissioner or an Inspector Any information or return which is false in any material particular commits an offense and is liable on summary conviction to a fine of $10,000. 24. Liability of Agent 18. Where an agent of an employer commits an act or default, which constitutes an offense, the employer is liable, unless the employer proves that the offense was committed without his consent or connivance. Limitation of liability 19. Proceedings shall not be brought against, and compensation shall not be payable by the Commissioner, an inspector or any other officer employed in administering the code in respect of any act done in good faith under the Code. Victimization 20. 1. A person who commits an act of victimization against another person commits an offense and is liable on summary conviction to a fine of $10,000. 2. For the purposes of subsection 1, a person shall be taken to commit an act of victimization against an employee if he subjects or threatens to subject the employee to any detriment, A. on the ground that the employee, I, has made, or proposes to make, a complaint under the Code, 2. has brought, or proposes to bring, proceedings under the Code against any person, 3. has furnished or proposes to furnish any information or documents to a person exercising or performing any power or function under the Code, I.V. has attended or proposes to attend an inquiry under the Code or to provide evidence or testimony as a witness, or 25. B.V. has made a good faith allegation that a person has committed an act of discrimination and contravention of the Code, on the ground that the person believes that the employee has done, or proposes to do, an act or thing referred to in paragraph A. Part 3 Settlement of Disputes Procedure for Settlement of Disputes 21. 1. A party to a dispute arising out of any matter contained in the Code or the employment relationship must make a bona fide effort to resolve the dispute through negotiation with the other party. 2. Where the parties have exhausted their efforts to resolve the dispute through negotiations, either party may report in writing the dispute to the Commissioner for conciliation, indicating the parties to the dispute, the nature of the dispute, the relief sought and the efforts made to resolve the dispute through negotiations. 3. Upon receipt of the notice of dispute, the Commissioner shall within 21 calendar days investigate the matter and facilitate a voluntary settlement by conciliation. 4. Where the Commissioner fails to achieve a settlement, he shall, within 14 days, transmit the matter as an unresolved dispute, with a full written report on the matter, to the Minister. Action by Minister 22. 1. On receipt of a report of an unresolved dispute transmitted by the Commissioner under Section 21. 4. The Minister may, A. himself or herself attempt to achieve a voluntary settlement of the issue, taking whatever steps he deems appropriate, including consultation with the Commissioner. Or 26. B. Refer the matter to the tribunal within 21 days. Or C. Permit the parties to submit their dispute to mediation. 2. Except for disputes in the essential services or disputes in the opinion of the Minister that are likely to endanger the health or safety of the public, the consent of the parties will be required before the Minister refers an unresolved dispute to the tribunal. Limitation on Industrial Action 23. 1. A strike shall not take place in an essential service. 2. A strike shall not take place in an undertaking that is not an essential service unless A. The parties have failed to resolve the dispute through negotiation and conciliation and the Minister has certified that the dispute is unresolved after conciliation. B. 50% plus one of the votes cast by affected employees voted in favor of a resolution for that action, and the recognized trade union has given at least 3 written notices to the Minister and the respective employer. 3. A lockout shall not take place in an essential service. 4. A lockout shall not take place in an undertaking that is not an essential service unless A. The parties have failed to resolve the dispute through negotiation and conciliation and the Minister has certified that the dispute is unresolved, and B. The employer has given at least 3 working days written notice to the Minister, the employees and any recognized trade union, of an intention to embark on that action. 27. 5. The strike or lockout shall cease on reference of the matter to the tribunal. 6. A person who contravenes this section commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Establishment of the Labor Tribunal and appointment of members. 24. 1. There shall be established a tribunal to settle any dispute or complaint transmitted to it under the Code. 2. The tribunal shall comprise a chairperson and 2 other members. 3. The minister shall appoint a chairperson who shall be a magistrate or, where existing commitments prevent a magistrate from accepting such appointment, the registrar of the court or an officer employed by the Crown, who is an attorney at law of at least 10 years standing. 4. The 2 other members shall be appointed by the minister upon recommendation of the parties to the dispute. 5. A person appointed to a tribunal under subsection 2 shall not be removed while being in charge of a case or before the expiry of his term, except for misbehavior or incapacity, whether arising from infirmity of body or mind, to perform his duties or any other disqualifying factor. 6. In the exercise of its functions, the tribunal shall not be subject to the control or direction of any other person or authority. 7. The Governor and Council shall provide administrative support for the tribunal. 2. The tribunal shall in the exercise of its powers findings of tribunal binding. 25. 1. The findings of a tribunal shall be binding upon the parties to the dispute and may only be appealed to the High Court on a point of law. 28. A. Make an order or award as it considers fair and just having regard to the interests of the persons concerned and the community as a whole, and B. Act in accordance with equity, good conscience and the substantial merits of the case before it having regard to the principles and practices of good industrial relations. 3. The tribunal, in determining what are the principles and practices of good industrial relations, shall take account of relevant conventions and recommendations of the International Labour Organization. 4. The tribunal shall not be bound by the rules of evidence in civil or criminal proceedings in determining any matter. 5. The tribunal shall not make an order as to cost except for exceptional reasons the tribunal considers appropriate. 6. For the purposes of enforcement, an order of the tribunal shall be treated as if it were an order, by whatever name called, of the High Court. Powers of tribunal to summon witnesses and administer oaths. 26. 1. A tribunal may summon any person to attend before it, and to give evidence or to produce any document or other record in the possession or under the control of such person. 2. A summons under this section may be served either personally or by registered post. 3. A tribunal may administer oaths or take the affirmation of any witness appearing before them. 4. A person who makes a false statement under oath or affirmation commits an offense and is liable on summary conviction to a fine not exceeding $5,000. Summons of tribunal to be obeyed. 29. 27. Any party appearing or any person summoned pursuant to section 26, 1, to attend and give evidence or to produce any document or other record before a tribunal shall be A. Bound to obey the summons served upon him, B. Entitled to the same rights or privileges as he would have before a court. Failure to obey summons of tribunal. 28. A person who fails to obey a summons served upon him pursuant to section 26, 1, commits an offense and is liable on summary conviction to a fine not exceeding $5,000. Tribunal to regulate own proceedings. 29. A tribunal shall regulate its own proceedings and publish general guidelines concerning the procedures to be observed. Arbitration Act, Chapter 105, not to apply. 30. The Arbitration Act or SA 105 shall not apply to any proceedings of the tribunal under this code or to any award made by IT. Part 4 Advisory COMMITTEE Tripartite Consultation. 31. The minister shall consult with employers and employees or their respective representatives from time to time on any matter affecting the administration of the code and the relationship between employers and employees and conditions of employment in general. Advisory Committee. 32. 1. The minister may appoint an advisory committee to consider and recommend 30. A. Policies for the effective administration of the code. B. Policies for the promotion of greater collaboration and cooperation between employees and their trade unions on the one part and employers and their organizations on the other part. C. Policies for the promotion of productivity and competitiveness. D. Measures for the effective application of conventions of the International Labour Organization extended to Anguilla. H. General questions relating to migration to Anguilla for employment and the condition of migrant workers. 2. Subject to subsection 3. A committee shall consist of an equal number of employers and employees as well as any other representatives of interest groups as the minister deems appropriate. 3. The minister shall appoint a person who does not represent the interests of employers or employees to be chairperson of a committee. 4. The members representing employers and employees shall be freely chosen by the employers and employees' organizations. 5. A committee may hold public meetings to seek views and recommendations of employers, employees, and the general public. 6. A committee shall seek to determine by consensus all questions arising at its meetings. Reports of Committee 33. 1. The committee shall A. Issue reports with recommendations upon any matter referred by the minister. And 31. B. Issue an annual report with recommendations relating to the administration of the Code and employment relations in Anguilla. 2. The reports referred to in subsection 1 shall be addressed and delivered to the minister, along with any minority reports, if any. Part 5 Fundamental Principles and POLICY Promotion of Core Labor Standards and Fundamental Conventions of the International Labour Organization 34. 1. The Code shall be interpreted, as far as practicable, in a manner that is consistent with the fundamental conventions of the International Labour Organization, namely, I. Forced Labor Convention, 1930, Number 29, 2. Abolition of Forced Labor Convention, 1957, Number 105, 3. Freedom of Association and Protection of the Right to Organize Convention, 1948, Number 87, IV. Right to Organize and Collective Bargaining Convention, 1949, Number 98, V. Equal Remuneration Convention, 1951, Number 100, VI. Equality of Opportunity and Treatment in Employment and Occupation, 1958, NO.111, VA. Minimum Age for Admission to Employment Convention, 1973, Number 138, and VI. Elimination of the Worst Forms of Child Labor, 1998, Number 182. 2. The Code shall be interpreted in a manner that is consistent with conventions of the International Labour Organization that are extended to Anguilla as certified by the Governor and Council. 32 Policies underlying the Code 35. The following expressions of national policy provided in this section shall be used in interpreting the Code. A. The legitimate employment interests of citizens of Anguilla shall be paramount and override all competing concerns. B. The system of labor administration shall promote social dialogue among government, employers and employees through their representative organizations and labor management partnerships within workplaces. C. The system of labor administration and dispute settlement shall seek to reconcile competing interests of employers and employees in a fair and equitable manner, having regard to the need to promote competitiveness of the economy of Anguilla, the viability of employers' businesses and security of employment and decent working conditions for employees. D. The system of labor administration shall be implemented in a manner which is neutral, objective and independent of improper external influences. E. The Code shall be administered in a manner that provides employees and employers with access to a fair, inexpensive and efficient system of dispute settlement. F. Systems, procedures and institutional framework for the effective implementation, monitoring and enforcement of the provisions of this Code and the system of labor administration shall be promoted. G. Employers and employees shall be free, through the processes of collective bargaining or otherwise, to agree on wages and other conditions of employment, provided the agreements do not infringe the minimum conditions prescribed in this Code. Part 6 Basic Conditions of Employment 33 Particulars of Contract 36. 1. An employer shall inform the employee, at the time of his employment, of the nature of the job and the terms and conditions of employment. 2. Where the contract of employment is oral, the provisions of the code shall apply, insofar as they are relevant to the particular case. 3. Where the probationary period is to exceed 4 weeks, the employer shall furnish the employee with a letter of employment within 10 working days of engagement containing at least A. The name and address of the employer, B. The name and address of the employee, C. The date of commencement and duration of the employment, D. The job title, the general responsibilities and related duties for which the employee is being hired, E. The rate of pay and pay interval, F. The regular hours of work and rest periods, F. The period of probation, and G. The employee's leave and vacation entitlement. 4. Where an employee may be required to perform any other duties not specified in his letter of appointment, such other duties must be directly related to the employee's core functions. 5. Where any change in the existing terms and conditions of employment of an employee is contemplated, such change must be notified in writing to the employee and shall only be made after consultation between the employer and employee or his trade union. 6. Any change envisaged in subsection 5 shall not be less favorable than the terms and conditions of employment which the employee previously enjoyed, save for exceptional circumstances. 34. 7. Notwithstanding subsection 3, where there is no recognized trade union, the terms and conditions of an employee shall be reviewed periodically, not less than once every 3 years. Probationary period 37. 1. The probationary period of an employee shall be as specified for that class of employee in the schedule. 2. During the probationary period, the employer shall provide the employee with reasonable training and general orientation in the duties, responsibilities and policies relevant to the position for which he was hired, and the employee shall be informed by his supervisor or manager on a monthly basis of his progress. 3. Notwithstanding subsection 1, the employer may, where there is a valid reason for so doing, and after consultation with the employee or his representative, extend the probationary period for a further period, not exceeding the duration of the original probationary period, and written notice of that extension shall be sent to the Commissioner. 4. An employer shall, within 14 calendar days of the expiry of the probationary period, inform the employee in writing of whether the employee has satisfactorily completed the probationary period, failing which the employee is deemed to have satisfactorily completed the probationary period. 5. An employer who has informed an employee that he has satisfactorily completed the probationary period shall not place the employee on any further period of probation for the same job. Normal hours of work and weekly rest 38. 1. The standard workday, exclusive of meal and other agreed intervals, shall be 8 hours, and the standard work week shall be 40 hours. 2. An employer shall permit his employees to enjoy in every period of 7 consecutive days a period of rest comprising at least 24 consecutive hours. 3. Except as provided in subsection 2, an employer shall not employ a person in excess of 12 hours in any period of 20, 35, 4 hours, or in excess of 60 hours in a period of 168 hours. 4. The Commissioner may approve in writing a temporary increase in the hours of work authorized by the Code in an establishment in the following circumstances: A. In the case of an actual or apparent accident, or urgent work to the plant or equipment. B. In the event of abnormal pressure of work due to special circumstances, insofar as the employer could not be expected to resort to other measures. Or C. In order to prevent the loss of perishable goods, but in no case shall the night rest period or, for employees working at night, the day rest period be less than 8 hours. 5. Where the employer could not reasonably be expected to apply in advance for approval, that employer shall not be deemed to have contravened subsection 3. Meal intervals 39. 1. An employer shall not require or permit an employee A. to work for more than 5 hours continuously without a meal interval of not less than 1 hour, where subsection 2 has been applied, of not less than the agreed time. B. To perform any work during his meal interval. 2. An employer may agree with his employee to reduce the employee's meal interval to not less than 30 minutes. 3. For the purposes of this section, a period shorter than that specified under subsections 1A or 2 shall not be considered as a meal interval. Overtime pay 36. 41. Subject to subsections 2, 3, and 4, an employee in the hotel, tourism, entertainment, security, telemarketing, construction or other service sector shall be paid at the rate of time and a half his basic rate of pay for work done for his employer at the employer's request in excess of 40 hours in a week. 2. An employee in a sector other than those listed in subsection 1 above, who are daily rated paid shall be paid at the rate of 1.5 times for work in excess of 8 hours in a day. 3. An employee who works on a public holiday shall be paid at the rate of twice his basic rate of pay. 4. In arranging for overtime work, the employer shall take into account the special circumstances of young persons under 18 years of age, pregnant women, nursing mothers, persons with disability and family responsibilities of the employee. 5. The provisions of subsection 1 and 2 shall not apply to an employee who holds a position of supervision or management and other salaried employees whose terms and conditions of employment are fixed at a level which adequately compensates them, but such employees shall be entitled to compensatory time off at time and a half for each hour in excess of 40 hours per week. 6. An employer shall not classify an employee as holding a position of supervision or management if his duties and compensation are not commensurate with such status, and a tribunal appointed under the code or court may inquire into the matter and make a determination giving due regard to this section and to the right of an employer to manage his business. Payment where employee stopped or prevented from working full day or shift 41. 1. Where an employee who is paid by the hour is required to report for work and does so but is prevented from working by an act of God or force majeure, or is stopped from working by his employer or anyone lawfully acting for him, payment to that employee shall be made on the following basis. A. Where the employee works for more than 6 hours, the employee shall be paid for the day, or 37. B. Where the employee works for less than 6 hours, he shall be paid for the time so worked at his basic rate of pay. Pay for a period of standby or being on call or night work. 42. 1. Where an employee is required by his employer to remain on standby at the workplace, he shall be regarded as being on duty for that period and be paid wages accordingly. 2. Where an employee is required by his employer to remain on call for any period, the employee shall be paid an allowance to be agreed upon by the employer and employee or his representative trade union. 3. Where an employee does night work, he shall be paid a shift allowance to be mutually agreed by the employees or the recognized trade union and the employer. Payment in respect of public holidays. 43. 1. Where an employee who is paid by the day or by the hour, and where appropriate by piece or task, does not work for his employer on a public holiday, he shall not suffer loss of pay, that is to say, he shall be paid the basic wage he would have received for the work performed on that day, have it not been a public holiday, provided that he worked on his scheduled workday immediately before and his scheduled workday immediately after the said public holiday. 2. No deduction shall be made from the wages of an employee paid by the month, or the week or fortnight for time not worked on a public holiday. Distribution of service charge. 44. 1. In an establishment in which a customer pays a service charge, which is a specified percentage of the customer's bill, the employer shall cause the service charge to be pooled and distributed among his employees in a period of 4 weeks, in accordance with this section. 2. Where the establishment has at least 5 employees, the employer shall establish a service charge committee, in this section called the Committee for the Periodic Distribution of the Service Charge. 3. The committee shall consist of 3 representatives as follows. A. 1 person appointed by the employer to represent the employer. B. 2 persons representing the employees to be elected by the employees within the first 6 weeks of each year to serve for a term of 1 year, and the results of such election shall be filed with the Labor Department by the 31st of January each year. provided that where a person so elected is unable for any reason to serve his full term, the employees may elect another person to represent them in his stead and for the remainder of his term, and shall file the result of the election with the Commissioner within 14 days of obtaining that result. 4. The total amount of service charge accumulated over every period of 4 weeks, less 5%, which shall be retained by the employer to meet administrative expenses, shall be distributed among such employees and on such basis as may be decided by the committee. 5. The employer shall prepare a record showing the total amount of service charge accumulated in each period of 4 weeks, the total amount of government tax which has been deducted, if applicable, the amount retained by the employer for administrative expenses, a list of employees to whom the balance has been distributed, and the amount paid to each employee. 6. Tips or gratuities paid to an employee for his personal service may be distributed, but solely at the discretion of the employee who has received the tip and not by the committee or employer. Part 7. Protection of WAGES agreement to pay wages otherwise than in money, illegal. 39. 45. 1. The wages of an employee shall be made payable in Eastern Caribbean currency, United States currency, or with the consent in writing of the Commissioner, in any other currency which is accepted in Angola. 2. An agreement to pay wages in any currency or manner that is inconsistent with subsection 1 is illegal and void. 3. Where an employer pays an employee's wages by check drawn on a bank in Angola and the check is dishonored by non-acceptance upon presentation for payment, the employer is liable to pay to the employee, in addition to the employee's wages, A. 1/10 of the value of the employee's check, and B. Any charges the employee may have suffered upon presentation of the check, whether for the first time or a subsequent time. Agreement as to place or manner of spending wages, illegal. 46. 1. An employer shall not include in a contract of employment a condition, restriction or requirement which imposes any terms as to the place or manner in which the employee is to spend any wages or part thereof, and any such agreement or contract wherein such terms are expressed or implied is illegal and void. 2. Where stores for the sale of commodities to employees are established or services operated in connection with an undertaking, the employees concerned shall not be compelled either directly or indirectly to make use of such stores or services. 3. An employer or other person who seeks to impose on an employee a condition as to the place or manner in which the employee's wages are to be spent is guilty of an offense under the Code. Wages to be paid entirely in money and on working day. 47. 1. Except where expressly permitted by the Code, wages shall be paid on working days only and at or near the workplace. 42. Where an employee is paid wages by check or bank deposit or money order, the employer shall provide reasonable time off with pay for such employee to conduct bank transactions relating to his pay. Wages to be paid directly to employee. 48. Except where the employee directs otherwise, wages shall be paid directly to the employee to whom they are due or to a person specified by him in writing. Wages not to be paid on certain premises. 49. An employer shall not pay wages within any place that sells liquor, except where the employer is the resident owner or occupier paying wages to an employee bona fide employed by him. Pay periods. 50. 1. An employer shall pay or cause to be paid wages to his employees at regular intervals, or on the agreed pay day, which may be daily, weekly, fortnightly, or monthly. 2. Pay periods may be fixed by contracts, collective agreements, arbitration awards, or the Commissioner. Authorized deductions. 51. 1. An employer may deduct from remuneration payable to an employee under any contract of employment the following: A. Any tax, rate, or other deduction imposed by law. B. Any cash advance on account of unearned wages or loans. C. Any sum of money which an employee has authorized in writing to be deducted for other purposes, except for the purpose of obtaining or retaining employment, or for in respect of any fine, or for bad or negligent work, or for damage to 41. The materials or other property of the employer not ordered by the court. 2. The total sum, which may be deducted in any pay period, shall not exceed 1/3 of the gross wage, excluding the value of any payments in kind, of the employee in the applicable pay period. 3. Nothing in this section shall prevent an employer from recovering from an employee whose employment has been terminated the outstanding balance of a loan granted by the employer to the employee, and such amount may be deducted from any accrued gross wages due to the employee. 4. An employee charged with the handling of cash shall not be required to reimburse the employer for any portion of any shortages thereof, unless, upon a thorough internal investigation, such employee was found to be dishonest, negligent or reckless in the performances of his duty, or has admitted to theft. Prohibited deductions 52. 1. Where an employer has made to an employee an advance on account of unearned wages, he shall not make any deductions by way of discount, interest or any similar charge on such advance. 2. An employer shall not seek to recover from an employee, whether by way of deduction from wages or otherwise, any sum or fee incurred in relation to the recruitment of the employee, including work permit fee, visa fee or security bond. 3. Nothing in this section precludes an employer from granting a loan with interest to his employee, provided that the loan is not an advance on unearned salary. Payment of wages on termination of employment 53. 1. All wages due to an employee on termination of his contract of employment shall be paid to him immediately or no later than 1 week after his contract of employment has been terminated. 2. In the case of casual employees employed for short periods, wages shall be paid immediately on completion of the work. Remuneration other than wages 42.54. 1. An employer may, with the prior written agreement of the employee, give to an employee as partial payment of remuneration, other than wages, allowances in kind which shall a. be of personal benefit to the employee and his family and be appropriate for the use of the employee and his family, b. be of fair and reasonable value appropriate to the monetary value placed on the allowance by the employer, c. not be in the form of intoxicating liquor, tobacco, cigarettes, noxious drug or substance, or weapons, and where such allowance in kind is customary or desirable in the particular industry or occupation concerned. 2. The allowance in kind permitted under subsection 1 shall not exceed in its cash value 1/3 of the employee's regular wages in respect of a completed pay period. 3. The question of whether or not the partial payment of remuneration, other than wages, as allowances in kind falls within the meaning of subsection 1 shall be decided by the Commissioner, and the Commissioner's decision shall be final. Employee's right to recover 55. Where an employer has paid an employee wages in a manner contrary to this part, the employee shall, even if he accepted payment in the manner made, be entitled to recover in a court of summary jurisdiction so much of his wages, exclusive of sums lawfully deducted under this part, that was not paid to him in legal tender. Wages to be priority. 56. Notwithstanding any provision in any other enactment, amounts owed to employees by reason of non-payment of wages and other remuneration shall constitute priority debt and shall have prior claim over all other debts in respect of the property of the employer. Register of payments to employees 57. An employer shall keep a register of payment of wages, service charge distributions, and all other payments to his employees, and then 43 employees entitled on demand to a copy of his account in any pay period. Limitation on attachments or seizure of wages 58. 1. Notwithstanding any provision in any other enactment, the wages of an employee shall be liable to attachment or seizure and execution only within the following limits: a. Up to 1/2 in respect of maintenance payments, b. Up to 1/3 in respect of all other debts of any kind and however contracted. 2. The proportions prescribed in subsection 1 shall not be applicable cumulatively on the ground that there are several debts or several creditors, the maximum proportion in all cases remaining 50% of the wages. The sums attached or seized shall be divided among the claimants in proportion to their established claims. Employers to issue details of wage payments 59. 1. An employer shall, at the time of paying wages to an employee, Provide that employee with a wage slip containing the following written details in respect of the wage period to which the wages relate. A. The name and occupation of the employee. B. The wage rate of the employee. C. The period to which the wage relates. D. In the case of daily paid employees, the number of hours paid for at ordinary rate and at overtime rate. E. The nature and amount of any bonuses or allowance paid. F. The gross wages earned by the employee. G. The amounts and nature of any deductions from gross wages. H. The amount of the net wage paid to the employee. 44 offenses under this Part 60. An employer or his agent who A. fails to pay wages to an employee when those wages are due and payable. B. Pays wages in a form, manner or place contrary to the provisions of this part. C. Makes any deduction from the wages of an employee or receives any payment from any employee contrary to the provisions of this part. D. Fails to provide an employee with the details of his wages due to him as required under this part. E. Pays an employee wages in whole or part in the form of intoxicating liquor, tobacco, cigarettes, noxious drugs or substance contrary to this part. F. Fails to distribute a service charge, share of profits or commission contrary to this part. G. Contravenes the provisions of this part for which no offense has been prescribed, commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Repayment of wages. 61. 1. On conviction of an employer under this part, the court shall have power to order the employer to pay the employee any part of his wages found by the court to have been unlawfully deducted from the employee's wages, or to repay the employee any sum received by the employer from the employee contrary to any provisions of this part. 2. Payment of any sum ordered by a court to be paid under this section shall not be in derogation of any right of the employee to recover the sum by any other proceedings, save that an employee shall not be entitled in any other proceeding to recover any amount which a court had ordered to be paid under the provisions of this part. 45. Actual offender to be proceeded against. 62. 1. Where an employer is charged with an offense under this part, he shall be entitled upon information laid by him to have any other person whom he charges as the actual offender brought before the court at the time appointed for hearing the charge, and if, after the commission of the offense has been proved, the employer proves to the satisfaction of the court that he had used due diligence to enforce the provisions of this part, and that the other person has committed the offense in question without the employer's knowledge, consent, or connivance, the other person shall be summarily convicted of the offense, and the employer shall be exempt from any penalty. 2. When it appears to the satisfaction of the commissioner at the time of discovering the offense that the employer has used due diligence to enforce the provisions of this part, and that the offense was committed by some other person, and also that it has been committed without the knowledge, consent, or connivance of the employer, then the commissioner shall proceed against the person whom he believed to be the actual offender in the first instance without first proceeding against the employer. Prosecution to be instituted within 1 year of offense. 63. No prosecution for any offense under this part shall be instituted after the expiration of 1 year from the date of the commission of the offense. Part 8. Minimum wages. Fixing of minimum wage. 64. 1. The governor and council may, by order, published in the Gazette, fix a minimum wage for A. employees generally, or B. any class of employees in a particular industry or undertaking or trade or occupation, and such minimum 46 wage shall be not less than the minimum wage specified under paragraph A. 2. A minimum wage order may contain such provisions as the governor and council thinks fit and may A. specify hours of work and other terms and conditions of service or employment in relation to any minimum wage. B. Fix different minimum wages for employees of different categories of undertakings engaged in the same employment. Establishment of Minimum Wage Committee. 65. 1. The governor and council may at any time appoint a minimum wage advisory committee to investigate the conditions of employment in such trade or occupation and to make recommendations for the fixing of minimum rates of wages. 2. The committee shall comprise the following members appointed by the governor and council. I. A chairperson nominated by the minister. 2. An equal number of members representing employers and employees. of which one member from each group should be from the hotel and tourism industry. 3. One member nominated by the annual Social Security Department. And IV, the Commissioner who shall be ex officio Secretary of the Minimum Wage Advisory Committee. 3. The members representing employers and employees shall be appointed by the Governor and Council after consultation with representative organizations of the employers and employees concerned, and in the absence of such organizations, with the employers and employees concerned. 4. The same committee may be appointed in respect of more than one occupation or trade or in respect of all occupations and trades. 5. Members of the committee shall be appointed for such period as specified in the instrument of appointment. 47. Procedure 66. 1. The committee shall meet at such times as may be necessary or expedient for the discharge of its functions. 2. The chairperson or, in the chairperson's absence, the deputy chairperson and one member, each from the employees and employers groups, shall constitute a quorum. 3. In the case of inequality of votes, the chairperson shall, in addition to his original vote, have a casting vote. 4. The committee may make rules for the regulation of its own proceedings and procedures. Publication of the recommended rates and power of Governor and Council to make minimum wages. 67. 1. On receipt of the recommendations from the committee, the Governor and Council shall cause the rates recommended to be published in the Gazette, and the public shall be given a period of at least 1 month in which to make any representation thereon in writing. 2. After consideration of the recommendations of the committee and the representations of the public, the Governor and Council may issue an order prescribing the minimum rates of wages payable and any other related matters for consideration in proposing the minimum wage. 68. In considering the proposed minimum wage or other terms and conditions of employment, the committee shall have regard to a. The general level of wages in Angola, b. The cost of living, c. The general level of competitiveness of Angola's economy generally and in particular its main industries. 48. D. The need to link wage rates with productivity levels of employees, and e. The protection of employees at effect of minimum wage. Order 69. 1. An employer to whom a minimum wage order applies shall, as from the date of effect of the minimum wage order, pay to the employee wages and such other terms and conditions of employment which are not less than the minimum wage prescribed in the minimum wage order. 2. Where an employee enjoys wages and terms and conditions of employment that are already more favorable than those prescribed in the minimum wage order, his employer shall not reduce his wages or terms and conditions of employment to those prescribed in the minimum wage order. Posting of minimum wage order 70. An employer whose operations are affected by a minimum wage order shall cause the order to be displayed on a notice board in a conspicuous place in the establishment at offenses in relation to this part. 71. An employer who contravenes this part commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Part 9 AVE Annual Holiday Terms and Conditions. 49. 72. 1. Subject to subsection 2. An employee shall at the end of each year of employment with an employer be entitled to annual paid holiday as follows. 12 working days where he is employed with the employer for less than 5 years. 2. 15 working days where he is employed with the employer for more than 5 but less than 10 years. And 3. 20 working days where he is employed for 10 and more years, but such periods of annual holiday are not cumulative for more than 3 months from date of entitlement unless otherwise agreed in writing in a document signed by both the employer and the employee. 2. Annual paid holiday accrues from the anniversary date of the employment of the employee with the employer. 3. The annual paid holiday shall be given and taken in one period, or not more than 2 periods subject to a signed agreement by the employer and employee. 4. Where the employer and employee so agree, the annual paid holiday or either of such separate periods may be taken wholly or partly in advance immediately before the commencement of the annual holiday. 5. The annual paid holiday shall be taken by the employee before the end of 3 months of entitlement, provided that such annual paid holiday may, with the approval of the Commissioner, be further postponed for a specified period for good reason. 6. Subject to the provisions of this part, the employer shall determine the date on which the annual paid holiday shall commence and shall give to the employee not less than 7 days notice of such date, but such notice may be waived by mutual consent in writing. 7. Where the annual paid holiday or any part thereof has been taken before the right to such paid holiday has accrued, the right to a further annual paid holiday shall not begin to accrue until after the expiration of the period of the year of employment in respect of which the annual paid holiday or part thereof has been so taken. 58. Periods of absence from work due to maternity leave, or to illness or injury for a period not exceeding 3 months, shall not be deducted from the period of an employee's service for the purpose of the calculation of annual paid holiday entitlement. 9. Periods of casual leave taken by an employee shall be deducted from his annual paid holiday entitlement. Payment in respect of annual holiday 73. 1. An employee's annual holiday pay shall be calculated on the basis of the employee's wages in respect of the period of employment to which such annual holiday relates. 2. An employee who works for less than 12 months but more than 153 days during a period of 12 months shall be entitled to paid annual holiday on a proportionate basis. Exclusions from annual holiday 74. A period of annual holiday shall not include any period A. of sick leave to which the employee is entitled, B. of maternity leave to which a female employee is entitled, C. of disability caused by accident or disease for which compensation is payable under the provisions of the Code or any other enactment, D. for which an employee is called to serve on jury duty or national service or public duty, or E. of public holidays. Paid annual holidays upon termination 75. 1. Where an employee's employment has been terminated, he shall be paid wages in lieu of annual paid holiday or proportionate part due and not taken. 51. 2. Where the employee has taken his paid annual holiday in advance of his entitlement, the employer shall be entitled to deduct the sum paid in annual holiday in advance from any amounts payable to the employee upon termination. Sick leave 76. 1. An employee, other than a casual employee, who due to illness is unfit for work, shall be eligible for sick leave with pay on the basis of 1 day for every 22 days worked, provided that he has worked for his employer for at least 110 days. 2. An employee, other than a casual employee, who due to illness is unfit for work, shall be eligible for sick leave with pay for up to 2 normal working weeks per year, provided that he has worked for the employer for more than 12 months. 3. Where the employment contract provides for part-time employment, an employee shall be eligible for sick leave in accordance with subsection 1. 4. Notwithstanding subsections 1 and 2, an employee shall not be eligible for sick leave pay from his employer for any period of illness, A. in respect of which he is entitled to be paid sick leave benefit under the Social Security Act or SACS 045, or compensation under the Workmen's Compensation Act, R.S.A. CW 030 where such benefit is equal to the wages which he would have received for the period of illness, or B. in respect of which he fails to notify his employer within the first working day of his illness, and if the period exceeds 2 days, to furnish the employer with a certificate from a duly qualified medical practitioners, stating that he is unfit for work due to an illness, and specifying the period of unfitness for work. 5. Subject to subsection 3. The minimum remuneration payable by an employer during any period of sick leave shall be the normal rate of wages less any amount to which the employee is entitled by virtue of the Social Security Act, R.S.A. CS 045 or the Workmen's Compensation or SACW 030. 52. Maternity leave 77. 1. On the production of a certificate from a duly qualified medical practitioner stating the presumed date of confinement, a female employee who has completed 12 months continuous employment shall be granted the period of maternity leave with pay by her employer. 2. The period of maternity leave shall not be less than 14 weeks, of which not less than 6 weeks shall be taken after the date of confinement. 3. The remainder of the period of maternity leave may be taken before the presumed date of confinement or following the period of compulsory leave, or partly before the presumed date of confinement and partly following the period of compulsory leave. 4. The leave before the presumed date of confinement shall be extended by any period elapsing between the date of the actual date of confinement and the period of compulsory leave to be taken after confinement shall not be reduced on that account. That additional period of maternity leave 78. Where a duly qualified medical practitioner certifies that an illness necessitating absence from work arises out of pregnancy or confinement or both, the employer shall grant the employee an additional period of maternity leave, without pay, not exceeding 3 months. That amount of maternity leave pay 79. The employer shall pay to an employee, during the full period of maternity leave not exceeding 14 weeks, the basic wage and remuneration, less any amount payable as maternity benefits under the Social Security Act or SAC, S045. Calculation of maternity leave pay 80. Maternity leave pay shall be calculated as if it were holiday pay as provided for in this part. Paternity leave 53. 81. Where a female employee is granted maternity leave under this section, the husband or cohabitant of the employee may, at the discretion of the employer, be granted paternity leave without pay for such period as requested in the application, but in any case not exceeding 1 month, to be taken during the period his wife is on confinement or not later than 6 months from the birth of the child. Employee not to be given notice of dismissal while on maternity leave 82. An employer is prohibited from giving notice of dismissal to a female employee while she is absent from work on maternity leave, and any such notice shall be deemed to be unlawful. Special leave for jury service and other purposes 83. 1. An employer shall grant leave with full pay to an employee for the duration of jury service that the employee is required to give, provided that the employee shall be required to report to work for duty on those days where he is not required to be in court. 2. An employer shall grant leave with full pay to an employee who is required to attend any hearing of a tribunal constituted in accordance with Part 2 for the purpose of attending such hearing. 3. An employee may be granted leave with half pay for such period where he is representing Anguilla at the national level at any sport or cultural event approved by the governor and council. Penalties and employee's right to recover. 84. 1. An employer who a. enters into any agreement or gives any remuneration for employment contrary to this part, b. makes any deduction from the wages of an employee or receives any payment from an employee contrary to this part, commits an offense and is liable on summary conviction to a fine not exceeding $10,000, and for each subsequent offense to a fine not exceeding $10,000. 54. 2. An employee shall be entitled to recover in a court so much of his wages as have not been paid to him, including any entitlements under this part but exclusive of sums lawfully deducted, plus interest at the rate to be determined by the court. Part 10. Disciplinary action, termination of employment, and continuity of EMPLOYMENT. Disciplinary action by employer 85. 1. An employer may take disciplinary action against an employee for misconduct including a breach of employer's policy or unsatisfactory performance when it is reasonable to do so in these circumstances. 2. In deciding whether the employer has acted reasonably, regard shall be had to the nature of the violation, the employee's duties, the penalty imposed by the employer, the procedure followed by the employer, the nature of any damage incurred in the previous conduct, and the circumstances of the employee. 3. Means for the purposes of this section disciplinary action a. A verbal warning, b. A written warning, c. Suspension of not more than 1 week with half pay, d. Demotion, e. Dismissal. No employer may impose a fine or other monetary penalty valid reason for termination. 4. On an employee. 55. 86. 1. It is unlawful for an employer to dismiss an employee without a valid and fair reason for such termination connected with the capacity or conduct of the employee, or with the operational requirements of the undertaking, establishment, or service. 2. An employer shall not discipline or terminate the appointment of an employee unless employer has informed the employee in writing of the nature and particulars of the complaint against the employee and has given the employee or his representative a fair opportunity to defend himself or herself. Unfair dismissal. 87. 1. It is unlawful for an employer to dismiss an employee or institute disciplinary action based on a. the employee's race, color, sex, religion, ethnic origin, national extraction, indigenous origin, social origin, political opinion or affiliation, trade union affiliation or activity, disability, sexual orientation, gender identity, serious family responsibility, or marital status, or, except for purposes of retirement and restrictions on work and employment of young persons and children, age, b. the employee's age, subject to any other enactment in force, or collective bargaining provisions or contractual provisions regarding retirement, c. a female employee's maternity leave or benefits, pregnancy or reason connected with her pregnancy, d. the employee's rights to join a trade union of his choice, e. the employee's temporary absence from work due to illness or injury taken in accordance with the code, unless it occurs frequently and is found to be an abuse of sick leave provisions of the code, f. the perception that the employee has or is carrying the HIV/AIDS unless the employee is engaged in work established as putting other persons at risk of 56 contracting the HIV/AIDS or unless the inherent requirements of the job permit the removal of that employee to other duties. G. the employee's absence from work due to compulsory military service, national service, public duty or other civil obligation in accordance with law. H. the exercise or proposed exercise of the right of the employee to remove himself from a work situation which he reasonably believes presents an imminent or serious danger to life, health or safety. I. the employee's participation or proposed participation in legitimate industrial action, including strikes. J. the filing of a complaint or the participation in proceedings against an employer involving alleged violations of the code. 2. An employer who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Constructive dismissal. 88. 1. An employee is entitled to terminate his employment contract without notice or with less notice than that to which the employer is entitled by any statutory provision or contractual term, where the employer's conduct has made it unreasonable to expect the employee to continue the employment contract. 2. Where the employee terminates the employment contract pursuant to subsection 1, he shall be deemed to have been unfairly dismissed by the employer. Summary dismissal for serious misconduct. 57.89. 1. An employer is entitled to dismiss summarily, without notice, an employee who is guilty of serious misconduct of a nature that it would be unreasonable to require the employer to continue the employment contract. 2. Serious misconduct includes but is not limited to a. theft or willful damage of property of employer or another employee at the workplace, b. commission of a fraudulent offense, or an act of dishonesty which destroys the confidence of the employer in the employee, c. possession or use of narcotic drugs or abuse of alcohol or possession of arms and ammunition at the workplace or outside the workplace while on duty, c. refusal to follow health and safety measures instituted at work thereby endangering the health and safety of employees or members of the public, d. gross insubordination or willful disobedience of reasonable and lawful orders given by the employer, e. breach of confidentiality except for reports made by the employee to law enforcement agency or government regulatory agency, f. conduct inconsistent with the terms of the employee's contract of employment. 3. The serious misconduct in this section is restricted to conduct which is directly related to the employment relationship and has a detrimental effect on the business of the employer or the work relationship. 4. When terminating an employment contract under this section, the employer shall provide the employee with a written statement of the precise reason for the action, and the employer shall be conclusively bound by the contents of the statement in any proceeding testing the fairness of the dismissal. 58.5. An employer who fails to provide the statement referred to in subsection 4 shall be stopped from introducing testimony as to facts which might have been included in the statement in any preceding testing of fairness of the dismissal. Warnings and termination for misconduct. 90. 1. Where an employee is found to be in breach of his terms and conditions of employment or is guilty of any misconduct such that the employer cannot reasonably be expected to continue to employ, and if it is repeated, the employer may give the employee a written warning outlining the particulars of the offense. 2. If an employee after being warned is again found to be in breach of his terms and conditions of employment or is guilty of any misconduct in the following 12 months, the employer may suspend the employee with or without pay, or with half pay for a period of 1 week, or with the approval of the Commissioner for such longer period as may be appropriate in the circumstances. 3. If an employee after being warned 2 or more times or warned and suspended is again found to be in breach of his terms and conditions of employment or is guilty of any misconduct in the following 12 months, the employer may dismiss the employee. 4. An employer shall be deemed to have waived his right to dismiss an employee for a particular offense if he has failed to do so within 12 months after knowledge of the particular offense, provided that any investigation has been completed. 5. Where a warning is issued to an employee under this section, a copy of that warning shall be forwarded to the Commissioner. Unsatisfactory performance. 91. 1. Where the employee is not performing his duties in a satisfactory manner, the employer may give him written warning and appropriate instructions to correct the unsatisfactory performance. 2. If the employee, after being warned, in writing, a further 2 times, does not during the following months demonstrate that he is able to perform and has performed in a satisfactory manner, the employer may dismiss the employee. 59. Dismissal for reason of incapacity or abuse of sick leave. 92. 1. Where an employee has been a. continuously ill for a period exceeding 26 weeks and absent from his job, or b. injured in a manner that makes it difficult or impossible for him to continue to perform his job, the employer, after a qualified medical practitioners has certified such incapacity and it is determined that the employee is incapable of performing his job, may dismiss the employee if such incapacity presents an undue hardship to the business or enterprise. 2. Where an employee has taken sick leave frequently to the extent that the employer reasonably determines that such absences present an undue hardship to the business enterprise or amounts to an abuse of sick leave, the employer may seek to discipline the employee in accordance with the code. 3. The burden of proving that the employee's sick leave absences were abusive and that such absences present an undue hardship to the business enterprise shall rest on the employer. Termination during probation. 93. 1. An employer may terminate the employment contract of an employee at any time during the probationary period for an invalid and fair reason with 24 hours notice. 2. Where an employment contract is for a specified term not exceeding 4 months, an employer may terminate the employee's services for any valid and fair reason with 24 hours notice. Termination with notice. 94. 1. An employer shall give an employee notice of termination of the employment contract on the following basis: a. Where the employee is paid at intervals of less than 1 month, who has 60 I. less than 1 year's service, 1 week; 2. 1 year and over and less than 5 years service, 2 weeks; 3. 5 years service and over, 4 weeks. B. Where the employee is paid at monthly intervals, who has 2, 3 less than 1 year's service, 1 month; 1 year and over and less than 5 years service, 2 months; 5 years service and over, 3 months. But where the employee is at the professional, higher technical or managerial level, the period of notice shall not be less than 3 months irrespective of length of service. 2. An employer may give the employee pay in lieu of notice equal to the wages and other remuneration and other benefits that would have been due to the employee at the end of the period of notice. 3. Where an employee intends to resign, he must give the employer notice similar to what he was entitled to receive from his employer. 4. Where an employee fails to give the notice required in subsection 3, the the employer shall be entitled to deduct from benefits due to the employee at the time of the termination of employment the sum equivalent to the wages due to the employee over the period of notice had he been employed during that period. Time off to seek alternative employment. 95. Where an employer gives an employee notice to terminate his employment contract, the employee may, if he so requests, be granted reasonable time off with pay by the employer to seek alternative employment. Remuneration due upon dismissal. 61. 96. Where an employee is dismissed for misconduct or unsatisfactory performance or breach of contract in accordance with this part, he is entitled to remuneration and accrued paid holiday up to and including the date of the dismissal. Burden of proof. 97. 1. And claim complaint arising out of the dismissal of, or any other form of disciplinary action against, an employee, it shall be for the employer to prove the reason for the dismissal or discipline, and, if the employer fails to do so, there shall be a conclusive presumption that the dismissal or disciplinary action was unfair. 2. In a claim of constructive dismissal, it shall be for the employee to prove the reason which made the continuation of the employment contract unreasonable. 3. The test as to whether or not a dismissal or other form of disciplinary action was unfair is whether or not, under the circumstances, the employer acted reasonably and in accordance with the principles and practices of good industrial relations. Remedies for unfair dismissal. 98. 1. Where a tribunal determines that upon a dispute referred to the determination was unfair or illegal, the tribunal may order either that a. the employee be reinstated, b. the employee be re-engaged in a position that is substantially equivalent if the post held by the employee is not immediately available, or c. compensation be paid in lieu of reinstatement or re-engagement. 2. Where the tribunal orders that compensation be paid, it shall take into account, among other things, a. any annual paid holiday pay earned, but not taken. 62. B. Any wages lost by the employee, on account of the dispute, up to the date of determination of the issue by the tribunal. C. The termination notice to which the employee would have been entitled. D. The employment category of the employee, his seniority and the ease or difficulty with which he can secure alternative employment. And E. The duty of the employee to seek to mitigate his losses. Recovery of wages and notice pay. 99. 1. An employer shall pay outstanding remuneration and holiday pay due to an employee whose service has been terminated not later than the last working day before the termination becomes effective. 2. Without prejudice to any other method of recovery, an amount due as pay for a period of notice may be recovered by civil proceedings in a court. Winding up of employer's business, etc. 100. 1. The winding up of or appointment of a receiver with respect to an employer's business shall cause the employment contract of any employee to terminate 1 month from the date of winding up or the appointment of a receiver. 2. This section shall not apply where, notwithstanding the winding up or appointment of a receiver, the business continues to operate or is transformed. 3. Notwithstanding any enactment to the contrary, on the winding up of, or appointment of a receiver with respect to, an employer's business, the claim of an employee, or those claiming on his behalf, to the following payments to which he is entitled under the code or any contract shall have priority over other creditors, including the government and the social security system. A. Wages, overtime pay, commissions and other forms of remuneration including service charge relating to work performed during the 26 weeks 63 preceding the date of winding up or appointment of a receiver. B. Holiday pay due. C. Amounts due in respect of other types of paid absence accrued during the 12 months preceding the date of winding up or appointment of a receiver. And D. Compensation for unfair dismissal and other payments due to employees upon termination of their employment. Death of employer. 101. When the employer's personal or legal position formed the basis of the contract of employment, the death of the employer shall cause the contract of employment to terminate 1 month from the date of the employer's death. Certificate of employment. 102. 1. Where on the termination of an employee's employment contract the employee requests a certificate of employment, the the employer shall provide the employee with that certificate. 2. The certificate of employment referred to in subsection 1 shall include a. The name and address of the employer, b. The nature of the employer's business, c. The length of the employee's continuous service, d. The duties upon which the employee is employed during the employment contract, and e. The wages and other remuneration payable at the date of termination of the contract. 64. 3. A certificate of employment shall not contain the reason for termination of the employment contract or an evaluation of the employee's work, unless requested by the employee. Continuity of employment 103. A temporary cessation of work on any of the following grounds shall not constitute a break in an employee's continuity of employment: a. An industrial dispute, b. Illness for 2 days or illness certified by a qualified medical practitioners where the absence from work exceeds 2 days, c. Occupational injury, d. Maternity leave certified by medical practitioners, e. The operation of any law, f. An act of God or force majeure, g. Absence permitted or condoned by the employer, h. Temporary layoff, I. Suspension, j. Leave without pay. Rights of employees on change of ownership 104. 1. Where there is a change of ownership of a business or undertaking and the successor employer offers any or all involved employees continued employment with the business, the employees shall carry forward their service and accrued rights to the successor employer, unless the predecessor employer has paid the employee all service benefits accrued at the time of the change of ownership. 2. Where the employee accepts continued employment with the successor employer, the arrangements made at the time of the change of ownership in respect of the employee, including details of employee's length of service and accrued rights, shall be notified to the 65 Commissioner by the successor employer and a statement signed by the employee and jointly by the predecessor employer and successor employer. 3. Where the employer is a body corporate and there is a change in its corporate identity due to a merger or acquisition, amalgamation, restructuring, change of ownership or other similar circumstance affecting the rights of employees, the employer is deemed to have changed ownership for purposes of this section. 4. Where there is a change of ownership, the predecessor employer shall pay to those employees who have not been offered continued employment with the successor employer their outstanding wages, vacation pay, and any other entitlements due to them, including severance pay. 5. Where there is a change of ownership of a business or undertaking, the predecessor employer shall, where practicable, give at least 1 month's notice of that change in ownership to the employees at effect of sale of business 105. Where a person for any reason sells or disposes of a business, all of the obligations under the code of the person selling or otherwise disposing of the business are binding on the person acquiring the business. Termination due to redundancy 106. 1. An employer may terminate the employment of the employee for reasons of redundancy. 2. For purposes of subsection 1, an employee's position may be made redundant where termination is because a. The employer has modernized, automated or mechanized all or part of his business, b. The employer has discontinued to carry on all or part of his business, c. The employer has sold or otherwise disposed of all or part of the business. 66. C. The employer has reorganized or relocated his business to improve efficiency. D. The employer's need for employees in a particular category has ceased or diminished. E. It has become impossible or impracticable for the employer to carry on his business at its usual rate or level or at all, due to a shortage of material, a mechanical breakdown, a force majeure or an act of God, or F. Reduced operation in the employer's business has been made necessary by economic conditions including a lack of or change in markets, contraction in the volume of work or sales, reduced demand or surplus inventory. 3. Prior to terminating the employment of any employee under this section, the employer shall a. Inform the recognized trade union or, if none exists, the employee's representative and the employee as early as possible stating, I. The number and categories of employees to be terminated, 2. The reasons for the termination, 3. The period over which the termination is to take place. B. Consult as early as possible with the recognized trade union, or if none exists, the employee's representative, and the employee on I. The possible measures that could be taken to avert or minimize the adverse effects of such situations on employment, and 2. The possible measures that could be taken to mitigate the adverse effects of any terminations on the employees concerned. 67. C. Notify the Commissioner as early as possible, but not less than 6 weeks before the intended date of redundancy, giving relevant information, including a written statement of I. The reasons for the termination, 2. The number and categories of employees to be terminated, 3. The period over which the termination is to take place, IV. Whether there has been any consultation with the trade union, any other representative of the employees or with the employees themselves to mitigate the effects of the redundancy and the results of that consultation. 4. The Commissioner shall, as soon as possible after receipt of the notification under subsection 3, inform the Minister of its contents. 5. An employer who terminates the employment of an employee on the grounds of redundancy shall give preference to the re-employment of that employee if he decides to hire a person within a period of 6 months from the date of the termination to perform duties that are the same or substantially the same as those that were formerly performed by the employee, and shall make every reasonable effort to notify the employee who is entitled to the preference criteria to be used in selection of employees for termination on grounds of redundancy. 107. 1. The employer in selecting employees for termination on grounds of redundancy shall be guided by the following criteria. A. Need for the efficient operation of the undertaking, establishment or service. B. Ability, experience, skill and occupational qualifications of individual employees. C. Length of service of employees. D. Age of employees. Or 68. E. Such other criteria as may be appropriate under the circumstances. 2. Notwithstanding subsection 1, an employer, when conditions of redundancy exist, may invite employees to offer themselves for termination, provided that an enhanced severance benefits package over and above the minimum provision of the code is paid to the employees to be retrenched. Severance pay. 108. 1. On termination of employment due to redundancy, an employee who has completed 1 year of continuous service with his employer is entitled to be paid by the employer severance pay equivalent to A. 1 week's wage for each completed year of service up to the first 5 years. B. 2 weeks wage for each completed year of service in excess of 5 years and up to 10 years. C. 3 weeks wage for each completed year of service in excess of 10 years. 2. For the purpose of subsection 1, the amount of a week's pay would be calculated on the basis of the highest wage earned by the employer over the last year preceding his termination. 3. The payment of severance pay shall not affect the employee's entitlement, if any, to payment in lieu of notice, outstanding wages, wages in lieu of accrued annual holiday, and other remuneration for work performed by the employee or any other termination benefits. 4. Severance pay shall only apply in respect of the service of the affected employee after the commencement of the code. Retirement benefits. 109. 1. An employer shall make provision for retirement benefits to be paid to his permanent employees on reaching the retirement age by means of a pension plan, an annuity or provident fund or other form of retirement plan. 69. 2. An employer that does not have any retirement plan for its employees shall pay to an employee who retires after at least 20 years of service retirement benefits in an amount equal to severance pay for the period of service of the employee. 3. A pension plan, an annuity or provident fund or other form of retirement plan referred to in subsection 1 may be contributory with the employer's contribution being twice that of employees. Part 11 Equality of treatment and EMPLOYMENT definition of discrimination. 110. 1. For the purposes of this part, a person discriminates against another person if the first mentioned person makes, on any of the grounds mentioned in subsection 2, A, any distinction, exclusion or preference the intent or effect of which is to nullify or impair equality of opportunity or treatment in occupation or employment. 2. The grounds referred to in subsection 1 are a. Race, color, sex, religion, ethnic origin, political opinion or affiliation, indigenous population, social origin, national extraction, disability, HIV or perceived HIV status or other medical status, sexual orientation or gender identity, family responsibility, pregnancy, marital status or, except for purposes of retirement and restrictions on work and employment of young persons and children, age. B. Any characteristic which pertains generally or is generally imputed to persons of a particular race, sex, religion, color, ethnic origin, indigenous population, nationality, political opinion, disability, HIV or perceived HIV status or other medical status, sexual orientation or gender identity, family responsibility, pregnant state, marital status or, except for purposes of retirement and restrictions 70 on work and employment of young persons and children, age. 3. Discrimination on the grounds of HIV includes the requirement by an employer to have an applicant for a job or an employee subjected to an HIV test or to have an employee tested for HIV during his employment. 4. Discrimination on the grounds of pregnancy includes the requirement to have an applicant for a job subjected to a pregnancy test. 5. An employer is obliged to treat as confidential and protect the confidential status of an employee's HIV status. 6. An employer is obliged to adopt policies and practices to protect an employee with HIV from stigmatization in the workplace. Prohibition of discrimination 111. 1. Subject to sections 112, 113 and 114, an employer, or any person acting or purporting to act on behalf of a person who is an employer, shall not, in relation to recruitment, selection or employment of any other person for purposes of training, apprenticeship or employment, discriminate against that other person in a. The advertisement of a job, b. The procedures used for the purpose of determining who should be offered that employment, c. Determining who should be offered employment, d. The terms or conditions on which employment is offered, e. The creation, classification or abolition of jobs. 2. Subject to sections 118, 119 and 120, an employer shall not discriminate against an employee a. in the terms or conditions of employment afforded to that employee by the employer, b. in the conditions of work or occupational safety and health measures, 71, c. in the provision of facilities related to or connected with employment, d. by denying access or limiting access to opportunities for advancement, promotion, transfer or training, or to any other benefits, facilities or services associated with employment, e. by retrenching or dismissing the employee, or f. by subjecting the employee to any other disadvantage, h. by failing to protect the confidential status of an employee with HIV, I. by failing to provide reasonable accommodation for an employee with HIV. Bona fide occupational qualifications 112. 1. Nothing in section 111 shall apply to any distinction, exclusion or preference based on the grounds listed in section 110. 2. Where a genuine occupational qualification exists. 2. For the purposes of this part, a genuine occupational qualification for a job exists where a. the essential nature of the job calls for a particular race, sex, religion, national extraction, indigenous population, ethnic origin, social origin, disability, HIV status, pregnancy status, marital status or age, in dramatic performances or other entertainment for reasons of authenticity. B. In a religious institution, the essential nature of the job calls for a particular religious affiliation or belief, and the essential nature of the job would be materially different or unable to be carried out if performed by a person of a different religious affiliation or belief. C. The job needs to be held by a man or woman to preserve privacy or to comply with recognized cultural practices. 72D. The nature of the location of the establishment makes it impracticable for the holder of the job to live elsewhere than in premises provided by the employer, and I. The only such premises which are available for persons holding that kind of job are occupied, or normally occupied, by persons of the same sex and are not equipped with separate sleeping accommodation and sanitary facilities for persons of the opposite sex. And 2. It is not reasonable to expect the employer either to equip those premises with such accommodation and facilities or to provide other premises for persons of the opposite sex, or to work out a practicable solution or usage of such facilities for members of both sexes. E. The job requires a married couple, or F. On the grounds of disability, it is shown that I. The disability in question was a relevant consideration in relation to the particular requirements of the employment concerned, and the performance of the job would not be able to be carried out as a result of the disability. Or 2. Special facilities or modifications, whether physical, administrative, or otherwise, are required to be made at the workplace to accommodate the person with disability, which the employer cannot reasonably be expected to perform. Reasonable accommodation for religious observances. 113. 1. An employer shall provide reasonable accommodation to a request by an employee for time off for religious observances, practices, and beliefs, unless the employer can show that accommodation would cause an undue hardship to his business. 73. 2. Where an employee is given time off to observe the Sabbath or any other religious observance, the employer shall not be obligated to pay wages to the employee for the period of absence from work. 3. Where the employer cannot provide reasonable accommodation to an employee under subsection 1 without undue hardship to the employer's business or other employees, the employee will be required to report for duty, failing which disciplinary action may be taken, and the employer shall not be considered to have committed an act of discrimination under this part. 4. In considering a request by an employee or employees of a particular denomination for time off for religious observances, the employer shall take into consideration the interests of all other employees, including those belonging to other religions. National preference. 114. An employer shall A. Seek to employ a belonger of any woman in preference to a non-belonger where such national is found to be qualified and competent, and B. Not terminate the employment of a belonger in preference to a non-belonger. Special positive action. 115. Special measures taken by, or required of, employers of a temporary nature to promote equality of opportunity in employment shall not be deemed to be unlawful discrimination. Sexual harassment. 116. Any act of sexual harassment against an employee committed by his employer, or an employee of that employer, shall constitute unlawful discrimination based on sex. Equal remuneration. 74. 117. 1. An employer shall pay equal remuneration to men and women performing work of equal value for the employer. 2. For the purposes of subsection 1a, equal remuneration means rates of remuneration that have been established without differentiation based on the grounds of sex, and b. Work of equal value means work equal in value in terms of the demands it makes in relation to such matters as skill levels, duties, physical and mental effort, responsibility, and conditions of work. 3. The burden of proof to establish that equal remuneration has been paid shall rest on the employer. Partnerships. 118. 1. Where employment in a particular occupation is largely provided through partnership firms, it shall be an offense for such firms, or for persons proposing to form themselves into such a partnership firm, to discriminate against any person on the grounds set out in section 110 in the arrangements they make for the purpose of determining who should be offered a position as partner in the firm, or b. By expelling persons from, or subjecting persons in the firm to, detrimental treatment. 2. Subsections 1a and b do not apply if the treatment afforded to the partner or potential partner is based on an essential occupational qualification. Employer and employee organizations. 119. It is an offense for an organization of employers, trade unions or other organizations of employees, or any other organization whose members carry on a particular profession or trade for the purpose of which the organization exists, to discriminate against any person on the grounds set out in Section 11075. A. By refusing or failing to accept that person's application for membership. B. In the terms on which it is prepared to admit that person to membership. Or C. In the case of a person who is a member of the organization. I. By denying or deliberately omitting to afford him, or limiting his access to any benefits, facilities or services provided by the organization. 2. By depriving him of membership or varying the terms of membership. 3. By limiting his, or depriving him of, access to, or the acquisition of, leadership positions within the organization, or IV. By subjecting him to any other detriment or inducement to discriminate. 120. 1. It is an offense to induce, or attempt to induce, a person to do any act which contravenes this part by A. Providing, or offering to provide, the person with any benefit, or B. Subjecting, or threatening to subject, the person to any detriment. 2. An attempted inducement is not prevented from falling within subsection 1 because it is not made directly to the person in question, if it is made in such a way that the person is likely to hear it or hear it. Burden of proof 121. Except where otherwise provided in this part, the person alleging the violation of this part shall bear the burden of proving the prima facie case 76 of discrimination, inducement or attempted inducement, as the case may be, upon which the burden of proof shall shift to the respondent to prove otherwise. Offenses and penalties under this part 122. 1. Any person who A. commits an offense under this part, or B. otherwise contravenes the provisions of this part commits an offense and is liable on summary conviction to a fine not exceeding $10,000, and for a second or subsequent offense, to a fine not exceeding a further $1,000. 2. Where any partnership, or group of persons proposing to form themselves into a partnership, contravenes Section 111. 1. The individual partners shall, upon the contravention being proved, be each liable to a fine not exceeding $10,000, and for a second or subsequent offense, to a fine not exceeding a further $1,000. 3. Where an offense under this part has been proved to have been committed by an employer who is not a natural person, and is proved to have been committed with the consent or connivance of, or to have been facilitated by any neglect on the part of any director, chairman, manager or other officer, they shall each be liable to be proceeded against accordingly. Part 12 Protection of Children and Young PERSONS Prohibition of Employment of Children 123. 1. The minimum age for the employment of a person shall be 16 years, and it shall be unlawful to employ a person under the age of 16 years. 77. 2. A person who employs a person or causes a person under the age of 16, subject to exceptions provided for in subsection 3, commits an offense and is liable on summary conviction to a fine not exceeding $8,000. And in the case of a second or subsequent offense to a fine not exceeding $10,000. 3. This section shall not apply to A. Light work approved by the Governor and Council for children not below the age of 14 years and subject to the number of hours and other conditions determined by the Governor and Council after consultation with employers and employees' representative organizations. B. Artistic performances approved by the Governor and Council and subject to conditions determined by the Governor and Council after consultation with employers and employees' representative organizations. Or C. The exercise of manual labor by a child under order of detention in a reformatory or industrial school, or by a child receiving instruction in manual labor in a school, provided that such work is approved and supervised by a public authority. Liability of parent or guardian 124. Where a child is found to be employed in contravention of this part, the parent or guardian of that child is deemed to have committed an offense unless he proves that the employment occurred without his knowledge, consent, acquiescence or connivance and is liable on summary conviction to a fine not exceeding $8,000. and in the case of a second or subsequent offense to a fine not exceeding $10,000. Restrictions on employment of young persons 125. A person shall not employ a young person unless that young person has been found fit for the work he is expected to perform after a thorough medical examination, and the employer of a young person shall ensure that the young person is medically 78 examined every year and that he is fit for the work that he is expected to perform. 2. A person shall not, without the prior written consent of the minister responsible for education, employ during school hours a young person who is within the compulsory school age. 3. A person shall not employ a young person on night work, and for the purpose of this subsection, night work means work performed between the hours of 8 p.m. on one day and 6 a.m. on the following day. 4. A person shall not employ a young person in any form of work which the governor and council may, by order, declare to be hazardous work for the purposes of this section. 5. Where the Commissioner is aware of the involvement of a child or young person in the worst form of child labor, the Commissioner shall communicate and collaborate with other agencies of the Crown to ensure that the child or young person is removed from that kind of labor and rehabilitated. 6. For purposes of subsection 5, rehabilitation shall include access to education, training and social welfare. Penalties 126. A person who contravenes section 125 commits an offense and is liable on summary conviction to a fine not exceeding $10,000, and in the case of a second or subsequent offense to a further fine not exceeding $10,000. Inducement to commit an offense 127. A person who employs or induces another to employ or procures the employment of a child or young person in the worst form of child labor, commits an offense and is liable on summary conviction to a fine of $20,000 or imprisonment for a term not exceeding 2 years or both. Unpaid work 79. 128. A child or young person is considered employed whether or not he is in an employment contract or is paid or not paid for his services. Registers to be kept 129. 1. An employer shall keep a register of young persons employed by him. 2. The register referred to in subsection 1 shall contain particulars of the names, addresses and dates of birth of young persons, the names and addresses of their parents or guardians and of the dates on which they enter and leave the employment, and the employer shall on request at any reasonable time produce that register for inspection by any authorized public officer. 3. An employer who contravenes this section commits an offense and is liable on summary conviction to a fine not exceeding $10,000. And in the case of a second or subsequent offense to a further fine not exceeding $10,000. False representation as to age 130. A person who misrepresents the age of a child or young person for the purposes of contravening a provision of this part commits an offense and is liable on summary conviction to a fine not exceeding $10,000. And in the case of a second or subsequent offense to a fine not exceeding $10,000. Government's vacation work program for students 131. 1. The prohibitions and restrictions under this part on the employment of children and young persons shall not apply to students who participate in the government's vacation work program for students, except that a student shall not be engaged to perform any work which by its nature or the circumstances in which it is carried out is, in the opinion of the Commissioner, likely to jeopardize the health, safety or morals of the student. 2. For the purposes of subsection 1a, the Chief Education Officer shall, where students are required to participate in the vacation work program, prepare and submit a report to the Commissioner 80I in respect of the institutions in which the students are expected to work. 2. On the type of work the students will be engaged in. 3. On the duration of the work concerned. And IV on the number of hours to be worked by the students. B. The Commissioner may, after consultation with such persons as he considers necessary, prepare guidelines on the engagement of students to perform work under the vacation work program. Part 13 Forced LABOR Interpretation. 132. In this part, forced labor means demands all work or service which is exacted from any person under the menace of any penalty, and for which the said person has not offered himself voluntarily, provided that the term forced labor shall not include a. any work of a purely military character or service exacted by virtue of compulsory military service laws, b. any work or service which forms part of the normal civic obligations of the citizens of a fully self-governing country, c. any work or service exacted from any person as a consequence said work or service is carried out under the supervision and control of a public authority, and that the said person is not hired to or placed at the disposal of private individuals, companies or association, d. any work or service exacted in cases of emergency, that is any one of a conviction in a court to say, in the event of double calamity, such as fire, flood, famine, hurricane, earthquake, violent epidemic or epizootic diseases, invasion by animal, insect or vegetable pests, and in general any circumstance that would endanger the existence or the well-being of the whole or part of the population, e. minor communal services of a kind which, being performed by the members of the community in the direct interest of the said community, can therefore be considered as normal civic obligations incumbent upon the members of the community, provided that the members of the community or their direct representatives shall have the right to be consulted in regard to the need for such services. Prohibition of forced labor 133. One labor. No person shall impose or permit the imposition of force notwithstanding anything contained in paragraphs B and 2c of the proviso to section 132. No person shall impose or permit the imposition of forced or compulsory labor, a. as a means of political coercion or as a punishment for holding or expressing political views or views ideologically opposed to the established political, social or economic system, b. as a method of mobilizing and using labor for purposes of economic developments, c. as a means of labor discipline, d. as a punishment for having participated in strikes. 3. Any person who imposes or permits the imposition of forced labor is guilty of an offense and liable on summary conviction to a fine not exceeding $10,000 or imprisonment for a term of XXX years or both. E. As a means of racial, social, national or religious discrimination. A2A application to government. 134. 1. This part, with the exception of section 144(3), shall apply to the government of Anguilla. 2. Notwithstanding any enactment to the contrary, any work done by prisoners in the work release program for the benefit of private individuals may only be done where the working relationship is consensual. The prisoner enjoys wages and other conditions of work at the same level as other employees, and is at liberty to terminate such employment at any time. Part 14 Health, Safety and Welfare. Construction operation includes the construction, alteration, repair, maintenance or demolition of a structure, harbor facility, bridge, viaduct, waterworks, reservoir, pipeline, aqueduct, sewer or sewage system. Employee includes a person performing duties in the workplace with the expressed or implied permission of the operator of the workplace, on a part-time or full-time basis, whether or not the person is receiving remuneration for his services, and the expression, to employ, shall be construed accordingly. Employer means any person or undertaking, corporation, company, public or government authority or body of persons who or which employs any person under a contract of employment or uses the services of a dependent contractor, commission agent or contract worker, and may be an operator, principal contractor, contractor or subcontractor, employment agency, and includes the heirs, successors and assigns of an employer. Factory includes the premises in which manufacturing takes place, and the term includes any warehouse or storage place. Building operation, harbor operation, mine or quarry. Interpretation 135 in this part, unless the context otherwise requires. 83. Machinery includes all manufacturing equipment. Machines, whether operated manually or mechanically, prime movers of machines, units designed to transmit power or motion, units designed to transport items or persons in connection with the manufacturing process, appliances used in the process, and all the parts of the appliances. Occupier means the person who has the ultimate control over the affairs of a workplace or any other place of employment or work, and includes the self-employed. Operator of a workplace includes the owner of a building containing a workplace, the owner or hirer of a machine or implement used in a workplace other than the principal operator thereof, or a self-employed person to the extent that any obligation under this part relates to persons who are employed in or about or in connection with such machine, and who are in the employment or pay of such owner or hirer. Owner includes a trustee, receiver, mortgagee in possession, tenant, lessees, or occupier of any lands or premises used or to be used as a workplace, and the person who acts for or on behalf of an owner as an agent or delegate, and an owner does not become an employer at a construction site by virtue only of the fact that the owner has engaged an architect, professional engineer, or other person solely oversee quality control at a construction site. Prime mover includes an engine, motor, or other appliance which provides mechanical energy derived from steam, water, wind, electricity, the combustion of fuel or other source of energy. Sanitary conveyances include urinals, water closets, earth closets, privies, ash pits, and any similar conveyances. Duties of employers 136. 1. An employer at any workplace including a construction site shall ensure that a. The safe, sound, healthy and secure working environment is provided as far as is reasonably practicable. B. The measures and procedures prescribed by the code and the regulations are carried out. 84. C, D, E, F, G, H, I, J, K, L, M. Every supervisor and every employee performing work complies with the code and the regulations. Every reasonable precaution is taken in these circumstances for the protection of an employee. Reasonable precaution is taken in the circumstances to protect the general public who comes into contact with the work site. A written occupational safety and health policy is prepared and reviewed at least annually in consultation with the Committee or Safety and Health Representative, if any, or an employee selected by the employees to represent them, and develop and maintain a program to implement that policy. A copy of the Occupational Safety and Health Policy is posted at a conspicuous location in the workplace. The equipment, materials, and protective devices and clothing as prescribed are provided. The equipment, materials, and protective devices and clothing provided by the employer are suitable and adequate and maintained in good condition. The equipment, materials, and protective devices and clothing provided by the employer are used as prescribed. The workplace, machinery, equipment, and processes under his or control are safe and without risk to safety and health as far as is reasonably practicable. That the machine, device, tool, or equipment is in good condition, and that the machine, device, tool, or equipment complies with the code and the regulations. Registration of workplaces 85. 137. 1. The employer and operator of a workplace shall, within 6 months of the code coming into force, file with the Commissioner a notice stating a. The hazardous materials present in the workplace and indicating whether the workplace is a major hazard installation, and b. Other particulars as are prescribed by regulations. And the person who commences to operate a workplace subsequent to the coming into force of the code shall, within 3 months from the commencement date, file a similar notice. 2. When there is a material change in any of the particulars appearing in the notice filed in accordance with subsection 1, the employer and operator of that workplace shall, within 1 month of that change, file with the Commissioner a notice setting forth the details of the change. Risk assessment 138. 1. Every employer shall make a suitable and sufficient assessment of a. The risks to the safety and health of his employees to which they are exposed whilst they are at work, and b. The risks to the safety and health of persons not in his employment arising out of or in connection with the conduct by him of his undertaking, for the purpose of identifying the measures he needs to take to comply with the requirements and prohibitions imposed upon him by or under the relevant statutory provisions. 2. Any any assessment referred to in subsection 1 shall be reviewed by the employer who made it if A. there is reason to suspect that it is no longer valid, or B. there has been a significant change in the matters to which it relates. 86. And where as a result of any review, changes to an assessment are required, the employer or self-employed person concerned shall make them. 3. Where the employer employs 20 or more employees, he shall record A. the significant findings of the assessment, and B. any group of his employees identified by it as being especially at risk. 4. Arising out of the risk assessment, the employer shall inform his employees of the risks identified and the measures adopted to prevent or control the risk. Safety and Health Policy and Emergency Plan 139. 1. An employer of a workplace where 20 or more employees are employed shall prepare or revise, in consultation with the employee's representatives, A. written statement of his general policy with respect to the safety and health of the employees, specifying the organization and arrangements for the time being in force for carrying out the policy and the provisions of the code, and B. an emergency plan in writing, in collaboration with the Department of Disaster Management and Fire Services Department, based on a risk assessment which shall include I. suitable and rapid means of obtaining first aid help and transportation from the workplace to a hospital for injured workers, and 2. measures and procedures to be used to control a major fire, to react to serious damage to the workplace, to evacuate the workplace and to notify rescue personnel, and the employer of the workplace shall submit the statement or the emergency plan, as the case may be, and any revision thereof to the 87th Commissioner, and bring them to the notice of all persons employed in the workplace. 2. An employer of a workplace shall ensure, as far as is reasonably practicable, that no unsafe structure exists in the workplace that is likely to expose persons to risks to bodily injury. Health 140. The employer and operator of a workplace shall A, B, C, D, E, F, G, H keep the workplace in a clean state and orderly manner, keep it from becoming overcrowded, maintain a reasonable temperature in the workplace, provide adequate ventilation in the workplace, provide adequate lighting, provide effective means for draining floors, provide adequate sanitary conveyances, and implement a regular and effective regime to prevent the breeding of insects, rats, mice, or other vermin. 1. The employer and operator of a workplace shall A. take adequate measures for the prevention of fire and all other hazards and for adequate means of escape for employees. B. Ensure that all machinery used is operated and maintained in a manner as to be safe for employees. C. Ensure that the workplace is properly maintained. D. Provide safety training, where appropriate. Safety 141.88E. Provide fire extinguishers for the class of fires. 2. The employer is entitled to remove an employee who the employer has reasonable cause to believe is under the influence of alcohol, addictive drugs, or any other substance which may adversely affect the health and safety of the employee or other persons in or about the workplace, and to request the employee to take a drug test. Welfare 142. The employer of a workplace shall, as the particular circumstances require, A. make available adequate supply of wholesome drinking water, B. provide and maintain suitable hand-washing facilities, C. provide accommodation for clothing not worn during working hours and for the drying of work clothing, D. provide and maintain suitable facilities for employees to sit during the course of their employment, E. provide and maintain readily accessible first aid kit, and F. provide and maintain other facilities such as canteen, mess rooms and restrooms, as are reasonable under the circumstances. Special Protective Measures 143. It is the responsibility of the employer of any workplace, as the particular circumstances require, to ensure that A. a person is not permitted to take food or drink into any room where any lead, arsenic, or other poisonous substance is used. 89. B. Suitable goggles or protective screens are provided to protect the eyes of any persons employed in a process involving a special risk of injury to the eyes. C. Where a work process involves a reasonable possibility of injury to other parts of an employee's body, Suitable protective equipment is furnished. D. An employee is not required manually to lift, carry or move anything in excess of the maximum weight specified by any regulations made under this part. E. Where a person is employed in any process involving exposure to wet or to any injurious or offensive substance, suitable protective clothing and appliances are provided and maintained. F. Where a process involves heat or steam, facilities adequate to protect employees from the heat or steam are provided and maintained. Protective clothing and devices 144. 1. Persons entering an area in a workplace where they are likely to be exposed to the risk of head, eye, ear, hand or foot injury, injury from air contaminant or any other bodily injury, shall be provided with suitable protective clothing or devices of an approved standard and adequate instructions in the use of the protective clothing or devices. And the person shall not be permitted to be in that area unless he is wearing the protective clothing or device. 2. The employer and operator of a workplace shall conspicuously display in areas where protective clothing or devices are required to be worn a notice to that effect. Hazardous materials 145. 1. An employer shall A. ensure that all hazardous materials present in the workplace are labeled in a way easily understandable to the employees, or are identified in the prescribed manner. 90. B. Obtain or prepare, as may be prescribed, an unexpired chemical safety data sheet for all hazardous materials present in the workplace. C. Ensure that the identification required by paragraph A and chemical safety data sheets required by paragraph B are available in English and other languages as may be prescribed. D. Ensure that when hazardous materials are transferred into other containers or equipment, the contents are indicated in a manner which will make known to employees their identity, any hazards associated with their use, and any safety precautions to be observed. And E. Ensure that information is provided on the handling and disposal of hazardous materials which are no longer required in containers which have been emptied but which may contain residues of hazardous materials, so that the risk to safety and health and to the environment is eliminated or minimized. 2. An employer shall ensure that hazardous materials is not used, handled or stored in the workplace unless the prescribed requirements concerning identification, chemical safety data sheets and worker instruction and training are met. 3. An employer shall advise the commissioner in writing if the employer, after making reasonable efforts, is unable to obtain a label or chemical safety data sheet required by subsection 1. 4. A copy of the most recent version of the inventory and of every unexpired chemical safety data sheet required by this part in respect of hazardous materials in a workplace shall be A. made available by the employer in such a manner as to allow examination by the employees. B. Furnished by the employer to a representative of Health and Safety Committee, if any, or to an employee selected by the employees to represent them, if there is no Health and Safety Committee, or if there is no trade union, an employee selected by the employees to represent them. 91. C. Filed by the employer with the commissioner on request, or if so prescribed. 5. A person shall not remove or deface the identification referred to in subsection 1A for hazardous materials. 6. An employer shall A. ensure that protective equipment necessary for handling hazardous materials is worn or used by employees at all appropriate times. B. Arrange for the initial and periodic medical examination and assessment of those employees who are exposed to risk of injury or of contracting a disease caused by contact with the hazardous materials. C. Keep a record of the results of examinations and assessments under paragraph B, which shall include the monitoring of the work environment. Special protection for pregnant employees 146. 1. An employer shall, after being notified by a female employee that she is pregnant and upon production of a medical certificate to that effect, adapt the working conditions of the female employee to ensure that she is not A. involved in the use of, or exposed to, chemicals, substances or anything dangerous to the health of the unborn child, or B. subjected to working conditions dangerous to the health of the unborn child, and where appropriate, the employer may assign alternative work, where available, to her without prejudice. prejudice to her right to return to her previous job. 2. An employer shall not require or permit a pregnant employee or an employee who is nursing her child to perform work that is hazardous to her health or the health of the child. 3. Notwithstanding any other law, during an employee's pregnancy, and for a period of 6 months after the birth of her child, her employer shall offer her suitable, alternative employment on terms and 92 conditions that are no less favorable than her ordinary terms and conditions of work. Employment of young persons on dangerous machines. 147. 1. In every workplace, a young person shall not work at a machine unless he has been fully instructed as to the dangers arising in connection with its operation, and the precautions to be observed, and A. has received sufficient training, documented and signed by himself or herself, in work at the machine, or B. is under adequate supervision by a person who has special knowledge and experience in the operation of the machine. 2. This section applies to machines of a dangerous character that a young person ought not to work at them unless the requirements of subsection 1 are observed. Disposal of waste. 148. An employer shall dispose of waste and effluents in a manner that does not result in any danger to persons, property, or to the environment. Noise and vibration. 149. 1. An employer shall take adequate steps to prevent hearing impairment caused by noise, and diseases caused by vibration, from occurring to persons in his workplace, and shall comply with directives as A. An inspector may issue, in order to reduce the level of noise or vibration generated by a machine, device, or process, and B. The chief medical officer may issue, in order to protect persons employed from hearing impairment caused by noise or from diseases caused by vibration. 2. An employer shall 93. A. Ensure that protective equipment necessary for compliance with subsection 1 is worn or used by employees at all appropriate times. B. Arrange for the initial and periodic medical examination and assessment of those employees who are exposed to the risk of injury to their hearing or of contracting a disease caused by vibration. C. Keep a record of the results of examinations and assessments under paragraph B, which shall include audiometric tests and the monitoring of the work environment. And D. Arrange programs for hearing conservation. Obligations of persons employed. 150. 1. An employee shall make use of all means, appliances, conveyances, or other things provided under the Code for the health, safety, and welfare of employees, to the extent that his employment involves their use. 2. An employee shall not A. willfully interfere with, misuse, or damage any means, appliance, convenience, or other thing. B. Willfully and without reasonable cause do anything likely to endanger himself or herself or others. Or C. Enter or remain at a workplace when under the influence of alcohol, addictive drugs, or any other substance which may adversely affect the health and safety of himself or herself or other persons in or about that workplace. 3. An employee shall report to his employer or supervisor. 94. A. The absence of or defect in any equipment or protective device or clothing of which he is aware and which may endanger himself or herself or another employee or person, and B. Any contravention of this code or any regulations of which he is aware. C. Report any hazardous situation. Prohibition of deduction of wages. 151. The operator of a workplace shall not, in respect of the cost of anything done or to be done by him in pursuance of this part or any regulations or order issued under the code, make any deduction from the sum contracted to be paid by him to any person employed, nor shall he receive or allow any other person to exact or to receive any payment in lieu of such deduction. Safety and health representatives. 152. 1. The employer shall, at a construction site or other workplace where a committee is not required and where the number of employees regularly exceeds 5, cause the employees to select at least one safety and health representative from among the employees at the workplace who does not exercise any managerial functions. 2. The safety and health representative shall accompany the inspector during an inspection and may make such representations as may be desirable to protect the safety and health of employees. Joint Workplace Safety and Health Committees. 153. 1. A joint workplace safety and health committee is required at a workplace at which 20 or more employees are regularly employed. 2. Subject to subsection 3. This section does not apply A. to an employer at a construction site at which work is expected to last less than 3 months, or 95. B. to other employer or workplace or class of employers or workplaces as may be prescribed by regulations. 3. A committee shall consist of A. at least 4 persons, for a workplace where fewer than 15 employees are regularly employed, or B. at least 6 persons or such greater number of persons as may be prescribed, for a workplace where 50 or more employees are regularly employed. 4. At least half the members of a committee shall be employees employed at the workplace who do not exercise managerial functions. 5. The members of a committee who represent employees shall be selected by the employees who do not exercise managerial functions and who will be represented by those members of the committee in the workplace. 6. Where there is a trade union or trade unions representing the employees referred to in subsection 1, the selection of the members of a committee referred to in subsection 1 may be delegated by a majority of such employees to the trade union or trade unions. 7. The employer shall select the remaining members of a committee from among persons who exercise managerial functions for the employer and, to the extent possible, who do so at the workplace. 8. A member of the committee who ceases to be employed at the workplace ceases to be a member of the committee. 9. 2 of the members of a committee shall, on a rotating basis, co-chair the committee, one of whom shall be selected by the members who represent employees and the other of whom shall be selected by the members who exercise managerial functions. 10. It is the function of a committee and it has power to A. Identify situations that may be a source of danger or hazard to employees. 96. B. Recommend to the employer and the employees the establishment, maintenance and monitoring of programs, measures and procedures respecting the safety of employees. C. Obtain information from the employer respecting I. The identification of potential or existing hazards of equipment and materials, processes or 2. Safety and health experience in work practices and standards in similar or other industries of which the employer has knowledge. D. Obtain information from the employer concerning the conducting or taking of tests of any equipment, machine, device, article, material, chemical, physical agent or biological agent in or about the workplace for the purpose of occupational safety and health, and E. Be consulted about and have a designated member representing employees be present at the beginning of testing referred to in paragraph D. Conducted in or about the workplace if the designated member believes his presence is required to ensure that valid testing procedures are used or to ensure that the test results are valid. Special powers of Inspector 154. 1. An inspector may take for analysis samples of material used or intended to be used in the workplace which he reasonably believes may prove on analysis to be likely to cause bodily injury to employees. 2. An inspector who has reasonable cause to believe that a condition exists at a workplace which is likely to cause bodily harm to any persons employed or performing duties shall serve written notice upon the operator thereof of an intention to recommend that the minister issue an appropriate order under this part of the code. 3. When an inspector is of the opinion that the employment of any young person in a workplace or any process or parts or may be 97 prejudicial to that young person's health, he may serve written notice on the operator of the workplace requiring the cessation of or the imposition of specified limitations upon that young person's employment and the requirements of the notice shall become an obligation under this part. Reports by employer 155. An employer shall, within 8 hours of death and 24 hours of a non-fatal accident referred to in this section, report to A. the Commissioner, the Joint Workplace Safety and Health Committee, the employee safety representative and the recognized trade union an accident involving an employee or any other person present in the workplace, which result in disability for more than 3 days or death. B. The Commissioner. I. Other accidents, fires and explosions. 2. The collapse or failure of any building or structure, And 3. Any accident to machinery or plant which results in the cessation of work beyond the shift or day on which the accident took place. Duties of an owner 156. The owner of a workplace that is not a construction site shall ensure that a. The facilities as prescribed by regulations are provided. B. The facilities prescribed to be provided are maintained as prescribed by regulations. C. The workplace complies with the regulations. And that the workplace is not constructed, developed, reconstructed, altered or added to, except in compliance with this act and the regulations. Exemptions and extensions 98. 157. 1. The minister may, by order, exempt a workplace from the application of one or more of the provisions of this part. 2. An order made under subsection 1 shall set forth the reasons and terms of the exemption. 3. The exemption shall be effective for not more than 6 months in the absence of an order of extension by the minister which shall set forth the reason for the extension. 4. An extension made under subsection 3 shall be effective for not more than 6 months in the absence of an order of further extension by the minister which shall set forth the reason for the further extension. 5. An order of exemption or extension may contain conditions which shall be met in order to qualify for the exemption or extension. Regulations in Orders 158. 1. The Governor and Council may make regulations prescribing the standards to be achieved in respect of any of the obligations set forth in this part and the methods required to attain them. And the Governor and Council may establish advisory committees on which employers and employees are represented to assist in this function. 2. The Governor and Council may, by order, a. require the operator of a workplace to take special measures bearing on the health, safety, or welfare of employees. B. Require the operator of a workplace to take specified measures bearing on the health, safety, or welfare of employees whose duties relate to the business of the workplace and are performed, in whole or in part, outside the workplace. C. Require arrangements to be made for medical supervision in any workplace. Or 99. D. Require medical examinations of employees in any workplace at the expense of the operator of the workplace to ascertain whether their health has been or is being adversely affected by their employment. Non-exclusivity of this part 159. Except where otherwise expressly provided, the provisions of this part shall be in addition to, and not in substitution for or diminution of, the provisions of any other part. Offenses 160. 1. A person who contravenes an obligation created under this part, or any regulations or order commits an offense. 2. If the contravention is by an employee, the operator of the workplace shall also be liable if it is proved that the operator failed to take reasonable steps to prevent the contravention. 3. Where an offense committed by the operator of a workplace under this part, or any regulations or order is proved to have been committed with the consent or connivance of, or to have been facilitated by any neglect on the part of any director, chairman, manager, other officer or person other than the operator, he, as well as the operator, is liable to be proceeded against. Multiple offenses 161. Where an employer employs persons in the workplace other than in accordance with this part or any regulations or order, a separate contravention is committed in respect of each person so employed. Penalties for specific offenses 162. 1. A person who fails to comply this section commits an offense and is liable on summary conviction to a fine not exceeding $10,000. 2. A person who 100. A. Forges or counterfeits any certificate or any record-keeping required by, under or for the purposes of this part or any regulations or order. B. Gives or signs any certificate knowing it to be false in any material particular. C. Knowingly utters or makes use of any certificate or so forged or counterfeited, or which is false as mentioned in paragraph B. D. Knowingly utters or makes use of any certificate as applying to a person to whom it does not apply. E. Falsely pretends to be an inspector. F. Willfully connives in any forging, counterfeiting, giving, signing, uttering, making use, personating or pretending referred to in this subsection. G. Willfully makes a false entry in any register, notice, certificate or document required by, under or for the purposes of this part or any regulations or order, H willfully makes or signs a false declaration required by, under or for the purposes of this part or any regulations or order, I knowingly makes use of any false entry or declaration referred to in paragraph G or H or J, encourages an employee to make a false statement, whether that statement is written or verbal, commits an offense and is liable on summary conviction to a fine not exceeding $10,000. 3. The operator of a workplace who a. obstructs or delays an inspector in the due exercise of any power conferred on him by or under this part, b. refuses to answer or falsely answers any inquiry authorized by or under this part, 101 c. fails to produce any register, book, document or other record he is required by or under this part to produce, or d. conceals or prevents, or attempts to conceal or prevent, any person from appearing before or being examined by an inspector, commits an offense and is liable on summary conviction to a fine not exceeding $10,000. Power of court to order cause of contravention to be remedy 163. Where the employer or operator of a workplace is convicted of an offense under this part, the court may, in addition to or instead of imposing a fine, order him, within the time specified in the order, to take steps as may be specified for remedying the matters in respect of which the contravention occurred, and may, on application, extend the time specified. Penalty for a person actually committing offense for which operator is liable 164. Where an act or default for which the employer or operator of a workplace is liable is in fact the act or default of some agent of the operator or other person, that agent or other person commits an offense and is liable on summary conviction to the penalty prescribed for the offense as if you were the employer or operator. Proceedings where inspector or operator believes the offender to be other than operator, 165. Offense 1. When it appears to an inspector at the time of discovery that a. the employer or operator of the workplace has used due diligence to enforce the execution of this part, b. that the offense has been committed by a person other than the operator, and c. that the offense has been committed without the consent, connivance or willful fault of the operator. 102. The inspector shall proceed against the person whom he believes to be the actual offender. 2. Where the commissioner is satisfied that a contravention of this part has occurred, he shall refer the matter to the Attorney General. Records as evidence 166. 1. Where an entry in a register or record is required to be made by this part or any regulations or order, a. an entry made in the register or record by or on behalf of the operator of a workplace shall be admissible as prima facie evidence of the facts stated in the register or record, and b. the absence of the entry shall be admissible as prima facie evidence that the requirement has not been observed. 2. Where in any proceeding under this part with respect to a young person, it appears to the court that the young person is of or below the age alleged by the defendant, the onus lies on the defendant to prove that the young person is not of or below that age. Other remedies 167. Compliance or non-compliance by an employer or employee with this part shall not prevent any person from seeking compensation under any other law. Part 15 or PRMITS Interpretation 168. In this part, unless the context otherwise requires, 103. Engage in employment means a. take or continue in employment, b. practice any profession, c. engage in any trade or business, or d. engage or be employed in any form of occupation, whether or not such employment, profession, trade, business, or occupation is taken, continued, engaged in, practiced or carried on for wages, reward, profit or gain. Self-employment means employment on one's own behalf and not under a contract of employment, express or implied. Temporary work permit means a work permit issued to a non-resident of Anguilla to enter and work in Anguilla for a single period not exceeding 1 month. Control of employment 169. A person shall not employ a person not belonging to Anguilla unless he has obtained a work permit or a work permit exemption in accordance with this part. Application for work permit 170. 1. An employer seeking to employ a person who does not belong to Anguilla shall file with the Labor Department an application in duplicate, in the prescribed form. 2. The minister may, in approving any work permit, impose any conditions he may consider appropriate to promote the work permit policy of Anguilla. 3. An application for renewal or extension of a work permit shall be made by, or on behalf of the person for whom the work permit is sought, by filing with the Labor Department an application in triplicate in the prescribed form and, unless the applicant intends to be self-employed, the application shall be accompanied by a statement in the prescribed form completed by the intended employer. 104. 4. The minister shall, in considering an application under subsection 3, take into account the extent to which the employer has complied with all statutory obligations. 5. An application for a temporary work permit or its renewal shall be made by the employer on behalf of the person for whom the permit is sought, by filing directly with the Labor Department an application in the prescribed form. 6. An employer shall not submit a work permit application on behalf of an applicant who is already on a valid work permit. 7. The minister may, after consultation with the commissioner, vary the conditions of a work permit granted under this section at any time. 8. An employer shall give an employee reasonable time off with pay to collect his work permit from the Labor Department and have his passport stamped with the appropriate visa within the time frame required by the Commissioner. Exemption 171. The following persons are exempt from the requirements of a work permit: A, B, C, D, E, F. The judges and officers of the Eastern Caribbean Supreme Court, members of Her Majesty's Regular Navy, military or Air Force, contracted persons in the service of the government of Anguilla, a person who is married to, and not living apart from, a national of Anguilla, diplomatic representatives accredited to Anguilla or to the United Kingdom by or under the authority of Her Majesty, representatives of the United Nations or any of its specialized agencies or of any similar international organization of which the United Kingdom is a 105 member. G. Representatives of any regional organization of which Anguilla is a member. Or H. Such other persons or classes of persons as the governor or governor and council may by order or certificate exempt. 2. Notwithstanding anything to the contrary in any other law, officers of the Eastern Caribbean Supreme Court does not include a barrister, solicitor or attorney at law engaged in private practice. Application requirements for work permit 172. 1. The employer applying for a work permit on behalf of a person shall provide the commissioner with the name, nationality, country of origin, passport number, and date and place of issue, proposed date of arrival in Anguilla of the person as well as proof of advertisement of the post in Anguilla and the reason for employing a non-national. 2. Upon receipt of approval for the processing of the work permit, the employer must submit the following to the commissioner: A. The completed application form. B. Medical certificate of fitness of the prospective employee. C. Certificate of character in respect of the prospective employee. D. A statement of the terms of employment of the proposed employee, including basic rate of pay, arrangements for accommodation, medical care and return travel of the prospective employee. 3. Where a work permit is granted, renewed or extended, it shall be in the prescribed form and its validity shall be dependent upon such terms and conditions as may be agreed by the minister. Rights of work permit holder 173. 1. A work permit holder, where recruited from abroad, 106 shall be informed of his terms and conditions of employment, arrangements for accommodation and return travel to his home country or country of recruitment prior to his arrival in Anguilla. 2. Except for domestic workers, a work permit holder shall not be compelled to live with his employer. 3. A work permit holder, who is employed as a domestic worker, is not obliged to remain in the household of his employer during periods of weekly rest and holidays. 4. A work permit holder shall have the right to keep in his possession his travel and identity documents. 5. A work permit holder is entitled to all the rights and benefits conferred by the Code, and any condition of employment that is inconsistent with the Code is void. False statements in Application 174. A person who makes a false statement in an application for a work permit or work permit renewal, whether in the prescribed forms or in response to any queries put to him in the course of an investigation during the work permit application process, commits an offense and is liable on summary conviction to a fine not exceeding $5,000. Fees 175. The Governor and Council shall, by order, specify the fee and security deposit to be paid solely by the employer for every application for grant, renewal or extension of a work permit under this part. Offense 176. An employer or any other person who contravenes this part commits an offense and is liable on summary conviction to a fine not exceeding $5,000. Part 16 107. Trade Unions and Employers Organizations 177. Interpretation in this part. Employers' organization or association means any combination established by employers, the principal purposes of which are the representation and promotion of employers' interests and the relations between employers and employees. Managerial employee means an individual who has managerial responsibilities and who works under a contract of employment. Registrar means the registrar of the companies and includes the person for the time being acting for him. Regulations means the regulations made under the Code by the Governor and Council. Rules means rules made by a trade union as authorized by this Code. Trade dispute means any dispute or difference between employers and employees connected with the employment or non-employment, or the terms of employment, or with the conditions of labor, of any person. Trade union means any combination of persons, the principal purposes of which are the representation and promotion of employees' interests and the regulation of relations between employees and employers, and includes a federation of trade unions, but not an organization or association that is dominated by an employer or employer's organization. Exemption 178. This part shall not apply to members of the Royal Anguilla Police Force, except those employed in their civilian capacity, but as far as possible their conditions of service should not be less favorable. Basic Employee Rights 179. Every employee has the right to 108. A. Take part in the formation of any trade union or federation of trade unions. B. Be or not to be a member of any trade union or federation of trade unions. C. Take part in lawful trade union activities. D. Hold office in any trade union or federation. E. Take part in the election of officers, shop stewards or safety representatives. F. Be elected an officer, shop steward or safety representative, or be a candidate for such election. G. Act in the capacity of an officer, shop steward or safety representative. H. Exercise any right conferred or recognized by the Code or any law and assist any employee, shop steward, safety representative, or trade union in the exercise of such rights. Freedom of association protection for employees 180. 1. No employer or employer's organization, and no person acting on behalf of an employer or an employer's organization shall, with respect to any employee or any person seeking employment, A. Require that he not join a trade union or relinquish trade union membership. B. Discriminate or take any prejudicial action, including discipline or dismissal, against such employee or person by reason of trade union membership or because of participation in lawful trade union activities. C. Discriminate or take any prejudicial action, including discipline or dismissal, against such employee or person because of his exercise or anticipated exercise of any right conferred or recognized under the Code or under any national law on employment or labor relations. 109. D. Threaten such employee or person that he will suffer any disadvantage from exercising any right conferred or recognized under the Code or under any national law or under any collective agreement. E. Promise such employee or person any benefit or advantage for not exercising any right conferred or recognized under the Code or under any national law on employment or labor relations. F. Restrain or seek to restrain such an employee or person by a contract of employment or otherwise. from exercising any right conferred or recognized under the Code or under any national law on employment or labor relations, and any such contractual term which purports to exert any such restraint shall be void, whether agreed to before or after the coming into force of the Code. 2. Nothing in this section shall be interpreted as preventing an employer from dismissing or otherwise disciplining an employee for a valid reason, in accordance with the Code. Protection of Trade Union from Employer Interference 181. No person shall commit an act which is designed to promote the establishment of an employee's organization under the domination of an employer or employer's organization, or to support employees' organizations by financial or other means with the object of placing such organizations under the control of employers or employers' organizations. And no compulsion to join or not to join an organization. 182. No person shall seek, by the use of any threat or intimidation, to compel or coerce any other person to join or not to join, or to support or not to support, any employees or employers' organization or union. Membership 183. 1. Any person eligible for membership in a trade union or employer's organization or federation under its constitution has the right to membership in that organization or federation if he pays any fees that 110 are properly payable to it, and such person has the right to remain a member as long as he complies with the rules of the organization. 2. No trade union or employer's organization shall discriminate in its constitution or through its actions against any person on the grounds of race, sex, sexual orientation, gender identity, religion, ethnic origin, national extraction, color, indigenous population, social origin, political opinion, disability, HIV or perceived HIV status, age, pregnancy, marital status or family, responsibilities. Federations 184. Trade unions and employers' organizations may participate in, be affiliated to, contribute to or join any national or international federation of trade unions or employers' organizations. Remedies 185. 1. Any complaint with respect to infringement of the rights and protection contained in the provisions of this part may be presented to the tribunal. 2. Where it is alleged in such complaint that an employee or person seeking employment was dismissed or denied employment contrary to this part, the burden is on the employer to prove that the dismissal or denial had no connection to the employee's or applicant's trade union membership or activities. 3. Where the tribunal finds that the complaint is well-founded, it shall make such order as it considers necessary to secure compliance with the provisions of this part, including an order for the reinstatement of an employee, if requested and deemed appropriate, restoration to him of any benefit, entitlement or advantage, and an order for the payment of compensation. Register of Trade Unions 186. The registrar shall keep a register of all trade unions registered under this act, with the name, date of registration, address, names of incorporators and officers and such other information as may be required by regulations. 111 Registration 187. 1. Every trade union and employer's organization shall be registered in accordance with the Code. 2. The rights and benefits conferred by the Code upon trade unions and employers' organizations and their members may be exercised only if those organizations are registered in accordance with this part. 3. Any 7 members or more of a trade union or 3 members or more of an employer's organization may, by subscribing their names to the rules of the union or organization and otherwise complying with the provisions of this act, apply to the registrar for registration as a trade union or employer's organization. 4. The applicants shall transmit 3 copies of the Constitution of the trade union or employer's organization, duly authenticated by signature of the President or Chairperson and Secretary, to the registrar along with the application for registration. 5. If the registrar is satisfied in respect of any application that a. the requirements of this section have been met, B. The Constitution is consistent with the Code of the Constitution of Angola and does not contain provisions which are contrary to any national law. C. The name of the trade union or organization is not identical to that of any existing trade union organization or so closely resembling such name as to be likely to deceive its own members or the members of the public shall forthwith register the trade union or employers organization and furnish it with a certificate of registration. 6. Any trade union or employers organization which was registered prior to the commencement of the Code shall automatically be considered registered under the Code. 7. The registrar shall determine the application for registration of a trade union within 28 working days from the receipt of the application. 112. 8. Any person aggrieved by any refusal or failure to register the trade union or employers organization shall be entitled to make an application for judicial review to the Eastern Caribbean Supreme Court. Constitution 188. The Constitution of every trade union and employers organization shall include the following information: A, B, C, D, E, F, G, H, I, J, the name of the trade union or organization, the objects of the trade union or organization, the qualifications for membership, provision for the office holders in the trade union or organization, among whom shall be the president or chairperson, a secretary or general secretary and treasurer, provision for periodic elections to all offices, and for the appointment of a temporary replacement if an office holder becomes disqualified or incapacitated from holding officer, provision for a general meeting open to all members, at least once every 2 years, a provision that any member or delegate in good financial standing may propose a resolution at a general meeting, subject to the notice requirement of the rules or constitution of the trade union, the fees and other subscriptions payable, and the maximum period of arrears permitted before a member loses his good standing, the grounds on which an officer or member may be suspended or expelled from office or from membership, the procedure for suspension or expulsion from office or from membership, including a provision that the affected officer or member be fully informed in writing of the allegations against him, that he shall have a reasonable 113 opportunity to meet those allegations, and shall have the right of appeal. K. Provision for the keeping of full and accurate records by the treasurer or other appropriate officer, for the annual audit of those accounts by an auditor appointed by the trade union or organization who shall not be a member of that trade union or organization, and for the availability to all members on request of full, audited annual statements of account. L. Provision for the banking and investment of the trade unions or organizations' funds. M. Provision for the paying out of the trade unions or organizations' funds, including the authority to sign checks, and the conditions under which a member may become entitled to any financial benefit provided by the organization. O. Provision for the amending of the Constitution. P. The duration of its financial year. Q. The inspection of the register of members and other books of the trade union or organization by its members. R. The manner of amalgamating with other trade unions or organizations. And S. The manner of dissolving the trade union or organization. Alterations in Constitution Name 189. 1. A trade union or employers organization may, in accordance with the procedures set out in its own constitution, alter its constitution. 2. The trade union or employers organization shall transmit the proposed alterations to the constitution or the new constitution to the registrar, and if the registrar is satisfied that said alterations are consistent with the code, the registrar shall certify the alterations to the Constitution and shall issue a certificate stating the approval and the date 114 on which it was given, and as from that date the new or altered Constitution shall have effect. 3. Any trade union or employers organization may change the name under which it is registered in the same manner as an alteration of the Constitution, and if the provisions of this section have been complied with, the registrar shall issue a new certificate and make the necessary alterations in the register. Annual return to registrar 190. 1. Within 6 calendar months after the end of each financial year, every trade union or employers organization shall submit to the registrar a return which shall include A. The trade union's or employer's organization address, B. The names and addresses of its current office holders. C. The number of fully paid up members of the trade union or employers organization. D. An audited annual financial statement. 2. The registrar shall suspend or withdraw registration of any trade union or employers organization which fails to submit a return in accordance with subsection 1. 3. Any trade union or employers organization subject to such a suspension or withdrawal under subsection 2 has the right to apply for judicial review. Legal status 191. 1. A registered trade union and employers organization shall be entitled to be incorporated as a body corporate with the capacity to contract and to hold property, and to sue and to be sued. 2. Notwithstanding subsection 1. No civil proceedings except those expressly allowed by the code or any other law may be brought against a trade union or employers organization issued with a certificate of registration or against any officer, representative or member thereof, in respect of any act done in good faith, done by or on behalf of such an organization in the furtherance or purported furtherance of the 115 objects of the Constitution. 3. Subsection 2 shall not be construed as exempting a trade union or employers organization or any of its officers, representative or members from contractual liability for goods or services, from obligations incurred in respect of property, or from liability for any criminal, malicious, or negligent act. Amalgamation 192. 1. A trade union or employers organization may, in accordance with its constitution and subject to the provisions of the code, amalgamate with any other trade union or organization. 2. In the event of amalgamation, the newly constituted trade union or organization shall assume all the rights and duties of its predecessor organizations unless the court on good cause shown upon the application of some interested party directs otherwise. Defunct organizations 193. 1. Upon application by a member of a trade union or employers organization, the registrar may, after making such inquiries as it may consider necessary, declare the trade union or employers organization to be defunct if the registrar is satisfied that it is no longer carrying on any of its activities for a period of over 2 years. 2. Any declaration made under this section shall include the winding up to the trade union or employers organization in such direction for the disposal of the trade unions or employers organization's assets as the registrar may consider just, having regard to the objects of the constitution of the trade union or the organization or resolution of the majority of the trade union members in good standing. 3. A trade union or employers organization subject to a declaration made under this section may appeal to Court of Appeal. Restraint of trade not unlawful 194. 1. The purposes of any trade union registered under the code shall not, by reason merely that they are in restraint of trade, be deemed to be unlawful so as to render any member of such trade union liable to criminal prosecution for conspiracy or otherwise. 116. 2. The purposes of any trade union registered under this code shall not, by reason merely that they are in restraint of trade, be unlawful so as to render void or voidable any agreement or trust. Prohibition of actions of tort against trade union 195. 1. An action against a trade union or against any members or officials thereof on behalf of themselves and all other members of the trade union in respect of any tortious act alleged to have been committed by or on behalf of the trade union shall not be actionable by any court. 2. Nothing in this section shall affect the liability of the officers of a trade union to be sued, except in respect of any tortious act committed by or on behalf of the union in contemplation of or in furtherance of a trade dispute. Conspiracy in relation to trade disputes 196. 1. An agreement by two or more persons to do or procure to be done any act in contemplation or furtherance of a trade dispute shall not be indictable as a conspiracy if such act committed by one person would not be punishable as a crime. 2. An act done in pursuance of an agreement or combination by two or more persons shall, if done in contemplation or furtherance of a trade dispute, not be actionable unless the act, if done without any such agreement or combination, will be actionable. 3. A crime for the purposes of this section means an offense punishable on indictment, or an offense which is punishable by summary conviction and for the commission of which the offender is liable under the law, making the offense punishable to be imprisoned either absolutely or at the discretion of the court as an alternative for some other punishment. 4. Nothing in this section shall exempt from punishment any person guilty of a conspiracy for which a punishment is awarded by any law in force in Angola. 5. Nothing in this section shall affect the law relating to riot, unlawful assembly, breach of the peace or sedition or any offense against the crown. 117. Removal of liability for interfering with another person's business. 197. An act done by a person in contemplation or furtherance of a trade dispute shall not be actionable on the ground only that it induces some other person to break a contract of employment, or that it is an interference with the trade, business, or employment of some other person, or with the right of some other person to dispose of his capital or his labor as he determines. Peaceful Pickleton 198. It shall be lawful for one or more persons, acting on their own behalf or on behalf of a trade union or of an individual employer or firm in contemplation or furtherance of a trade dispute, to attend at or near a house or place where a person resides or works or carries on business, or happens to be, if they so attend merely for the purpose of peacefully obtaining or communicating information, or of peacefully persuading any person to work or abstain from working. Cancellation of certificate of registration. 199. 1. The registrar may cancel a certificate of registration of a trade union in the following cases: A, B, C, D, at the request of the trade union to be evidenced in the prescribed manner, or in proof to his satisfaction that a certificate of registration has been obtained by fraud or mistake, that such trade union has willfully and after notice from the registrar violated any of the provisions of the code, or has ceased to exist. 2. The registrar shall, not less than 2 months previous notice in writing specifying briefly the ground of any proposed cancellation of certificate. 3. A trade union whose certificate of registration has been withdrawn or cancelled shall, from the time of such withdrawal or cancellation, absolutely cease to enjoy as such the privileges of a registered trade union, and shall be dissolved and proceed to wind up its 118 affairs, but without prejudice to any liability actually incurred by such trade union, which may be enforced against the same as if such withdrawal or cancellation had not taken place.